Item for delivery of judgment. Item numbers 47 and 48. RFA 73 of 2019 and RFA 51 of 2019.
RFA 73 2019 stands allowed. RFA 111 2019 stands dismissed. Receiver appointed in this matter stands discharged.
May please, Your Lordship. Lordship, as per the instruction of the parties, I want to withdraw this matter, Lordship.
Mr. Your name?
S. Borwa.
Mr. S. Borwa.
S. Borwa.
H. Borwa.
Yes.
Learned conducting counsel for the accused submits that he has the instruction to withdraw this petition. Fair allowed. This BA number so and so stands at disposal on withdrawal.
Item 50 for withdrawal.
Lordship.
Same word.
Okay.
For what can be item 1.
May please, Your Lordship. My lord,
Not received.
my lord, in this case, my lord, I'm struck, my lord, between the, my lord, the deadlock period, my lord, deadlock period between the section, my lord, 207 and 209 of CRPC, my lord. As on date, I am behind the bars 76 days. Case is, my lord, in pre-committal court, still in the court of SCJM, my lord, not committed to the court of session. And my lord.
No, let the TCR come. We'll
Yes, my lord.
consider.
My lord, I actually prepared one draft, my lord, regarding that, my lord, this deadlock period between 207 and 209. I want to place it before your lordship, my lord.
Okay,
Without
on next
lordship-
set we will consider.
Lordship,
Let the record come.
yes, yes, my lord.
Pardon,
Next
sir, your name,
lordship will dispose of, but my lord will see this.
Okay,
draft.
all right.
Yes,
Your name, please?
M. Rahman.
Mr. M. Rahman, learned counsel for the applicant, then Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that scan copy of the record was called for, but the same has not yet been received. Accordingly, it is provided that SSL lays the matter on cover next week,
Next week 14.
14th,
My lord, short date may be given, my lord, on last time it was on 28.
13th. Or SSL issue urgent reminder to the learned trial court for transmitting the scan copy of the record.
Item 2.
Problem, my lord.
May it please, Your Lordship. Lordship, allegation under FOXO, Your Lordship. So notice will have to go, Your Lordship.
Okay.
Yes, of course.
Issue notice. Fixing the matter on Borthakur.
48 months.
14.
48. Can it be
Okay.
after 17?
But then
he wanted to be fixed after 17 of
28 months.
20th. 20. Okay.
Item 3.
May please, Your Lordship. Matter relates to the NDPS Sec 21B, Lordship, intermediate quantity 2 days, 60 days petitioner behind the but charge.
How
sheet
many
al-
days?
60 days, Lordship. Charge sheet
60 days.
60 days. Charge sheet already has been filed in this case, Lordship.
Charge sheet not filed.
Filed, already filed.
Already
submitted,
filed.
Lordship. What
Okay.
happened, co-accused already, this petitioner arrest on the basis of co-accused statement in this case, Lordship. I have annexed all the co-accused, release bail order, Lordship, page,
Where?
page 39, Lordship. This is the 27A is their petitioner arrested on the basis of the co-accused statement, Lordship. This is reflected in the FIR as well as in the charge sheet also, Lordship.
No. When the co-accused was enlarged on bail.
Once, 1st July 2026, Lordship.
First
Annex
of July.
39. This is the bail order, Lordship.
Borthakur, what is the charge sheet number?
Charge sheet I have annexed, Lordship. I have
Yeah.
annexed.
Okay.
Page 22, this is the charge sheet.
What is the quantum of contraband substance?
Intermediate quantity, Lordship. This is reflected in the charge sheet also.
Total 551
Grams.
Grams,
Lordship. 187 grams.
Kindly page 27, Lordship, relevant part, how the petitioner arrested in this case, Lordship. The seized contraband weight 551 grams, including the soap cases, so and so, page 28, Lordship. Second para. As the
No,
place
no,
of
without the soap cases, or what is the weight?
187 grams, Lordship.
Without soap case.
187 grams.
187 is including the soap cases.
Soap cases at page 28, Lordship.
Okay,
Excluding
okay,
soap, Lordship.
okay.
Page 28, second paragraph, Lordship. Kindly read with Lordship. Page 28, second paragraph. As the place of occurrence fell within the jurisdiction of so-and-so police station, all seized article along with the apprehended accused person were handed over to OC so-and-so. Accordingly, registration of a case under was Lordship, first paragraph, Lordship. Other seized article included one Platina motorcycle, so-and-so, two mobile handset, one blue check lungi, one white plastic carry bag. During interrogation, accused Shahabuddin disclosed that the contraband had allegedly been supplied by one Ajad Alam Borbuya. This is the petitioner, Lordship, who was reportedly staying at his residence. He was arrested from the residence of the accused. What happened, Lordship? I have on oath, Lordship, paragraph, I have stated that, Lordship, petitioner is a small Agorwood businessman. He came to the co-accused to supply the Agorwood, Lordship. When he left the home of the
Then why you have been implicated?
Lordship,
Why you have been implicated?
I have demanded 3 lakhs rupees from of the Agorwood supply money, Lordship. That's why he included in this case my name, Lordship. And police also not seized the Agorwood. Agorwood was available with the motorcycle, Lordship. They have only seized the drugs articles, Lordship. They have not seized the Agorwood, Lordship. Paragraph 11, Lordship. Petitioner is a victim in this case. He is not a accused, Lordship. Paragraph 12, I have also stated, Lordship, in details. A co-accused already released on bail, Lordship, and notice what has been served, Lordship, for the regarding the arrest of the petitioner. This notice also served to the wife of the co-accused, Lordship, not to the any member of the family of the accused petitioner, Lordship. I have
Whether you
annexed
have
the
taken
notice
such
also.
ground here?
Notice also I have annexed, Lordship. Arrest memo, kindly see
No,
page
no,
30.
whether you have taken such a plea in this application?
This plea also I have also taken, Lordship. Page 34, this is the arrest memo, Lordship. Who has received the arrest memo? Razina Begum, wife of Shahabuddin. Who is the co-accused? Who implicated me in this case, Lordship?
Okay, we will pass the order. Next.
Oblige, Lordship.
Yes.
Well, also in this particular case, already three accused were already released by the honorable court. So only the petitioner is left. The main accused whose name was mentioned in the FIR, he was released on 5/8/2026. He was in BA number 2078 of 2026 by the coordinate bench of this honorable. Devakanto Nath. So on the grounds of parity or also I pray for regular.
So you are also the security guard?
I'm not the security guard.
Okay, who are you?
It's a housekeeping year also.
Housekeeping?
Yes, your lord.
Similar order, page number 16. Okay.
Yes. Oblige, your lord.
May I please, Lordship?
Yes.
Lordship, in this matter, accused person was arrested on 2/5, Lordship, 26, and has been behind the bar till that is more than 95 days, Lordship. And allegation is under section 87 BNS and read with section 4 of POCSO Act, Lordship.
POCSO Act.
Also, accused is just attaining age of 18 and the victim age is 70, Lordship. Kindly peruse the page number 24, Lordship. The deposition of
No,
victim,
no,
Lordship.
search it is submitted
Yes,
the
yes,
POCSO
yes.
Act also.
Yes, Lordship.
So at this instance, we have to issue notice.
Kindly peruse the page number 24, Lordship, deposition of the victim.
No, madam, you say, without hearing the other side, we cannot pass any order. Page number?
24, Lordship. This is on oath, Lordship. I am in love
No,
relationship.
no, no, not necessary to read out it. But how this statement will help you?
Lordship.
How this statement will help you?
Yes, Lordship. The victim girl insists the accused person, Lordship, to
Hmm.
take her away.
Maybe
Lordship.
you see,
The relation is love and affair, Lordship. He denied to take her away, but she insists him. He got scared and so he brought her back to Gauhati. May I read, Lordship?
not necessary at this stage. We will issue notice today to the victim. We will hear the victim. Thereafter, we will pass the order.
Lordship.
But
Can
even then, she is a child as defined in section 2D of the POCSO Act. She has not completed 18 years. So how this statement will help you? Anyway, issue notice to the respondent. Number 2, returnable on Bortakur from which place?
kindly allow us for that, Lordship.
Pardon?
Yes, the Lordship.
Silpukuri.
Let's get to
Oh, okay.
can go.
Scan copy of the record from the learned trial court and also issue notice to the respondent number 2, returnable on for that
13 August.
13th August. 13th of August.
Item 6. 6. Continuing.
May it please your lordship. Lordship, out of the same FIR, there is another bail application. CD was called and it is listed on 10th of
On
August. On 10th of August, my lord.
10th of August. Okay, on that day we'll peruse the CD.
DA one.
What is the number?
Bail application 1906 of 26.
Okay. The learned counsel for the petitioner submits that in connection with bail application number
06 of
1906
26.
2026 arising out of the same PS case number
470 of 26. Nogao PS case.
Nogao PS case number so and so so and so. CD has already been called for, and on that day CD may be perused to dispose of the present petition also. Accordingly, it is provided that Resi shall take this BA along with BA number so and so so and so. And on that day, CD will be perused to dispose of the present application also.
I'm obliged.
Item 8.
বাকিখিনি লগাই দিব CD কল কৰা হ'ব।
May I finish, my lordship? The petitioner name is not in the FIR, my lordship, partship, and neither any cognizable offense made out against the petitioner in the FIR. The only thing in the mention in the petitioner ATM card has mentioned in the but the original, the main accused, my lordship, the leading accused, he has been already granted bail by the honorable court, my lordship. Lordship may come into the page number 70, where is the FIR, my lordship, and the maximum offense less than 7 years, my lordship. The petitioner has not served section 35 clause bracket 3, my lordship. And in fact, my lordship, section
No,
360.
why you are apprehending arrest?
My lordship, police are coming to my house now and then, my lordship. And I have small children in my home. I'm being a lady, my lordship. And small children at home, my lordship. The lordship has also protected one of the
Protocol CD is available.
motion, my lordship.
No, earlier CD was called for.
No, my lordship. Fast, my lordship. Other co-accused, the main accused, my lordship, granted bail, my lordship.
No, in connection with other bail application, CD was called for.
Then I have to take.
We can take it up, my lordship. Which case number 54.
When the other bail application was disposed of,
BA number, my lordship, 1661.
Okay, 14-7.
Then your lordship has given interim protection on the co-accused. Oh, your lordship has protected on the 1480, my lordship.
Okay. Art Mister, your name please?
Naramin, my lordship.
Learned counsel for the applicant, Mr. Portaku, learned additional PP for the status on respondent. Apprehending arrest in connection with Kolgasia police case number 54 of 2026 under section 482 of under section 318 within bracket 4, 316 within bracket 2 of BNSS 2020, BNS 2023. Read with section 14 of the Game and Betting Act within bracket Assam 1970. This application under section 42 of the BNSS 2023 is preferred by accused Hamida for grant of PRS paid. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. What is the FIR?
FR, my lordship, page number 17. Type copy is also there, my lordship.
On the basis of an FIR lost by SI Zitul Das of Kolgasia PS, Borpeta. When it was lost,
It was lost, my lordship. Uh, it-
31st of May 2026. The essence of allegation in the FIR dated so and so is that on credible information, acting on a secret, acting on a tip-off on 31st May 2026 at about 8:30 a.m. in respect of ongoing illegal betting and gambling during the Indian Premier League within bracket IPL through mobile phone at Harisala Bazar area. A raid and search was conducted at the house of Diwan Zahirov. And during the raid and search, police recovered couple of mobile phones, along with debit cards of various banks in the name of different persons. Thereafter, police conducted a raid in the rented flat of the said accused at Green Hillside Apartment, Bosisto, and recovered several debit cards belonging to different persons. The learned counsel for the applicant submits that the applicant is a lady and her name find no mention in the FIR, and she is being searched by police, and that she is ready to cooperate with the investigating agency, and that a coordinate bench of this court in BA number 1603 of 2026 by order dated 14/7/2026 has already granted the privilege of interim PRS bail to the main accused And
Interim bail
under
is
such
not the main issue,
circumstances,
my
he
lord.
is contented to allow this application. Per contra, Mr. Bortakur submits that. CD
Yes.
submits that,
On 19.
CD may be called for. Whereas, having heard the submission of learned counsel for both the parties, it is provided that Mr. Bortakur shall produce the case diary before this court on 19th. Whereas, in the interim, considering the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, and further considering the fact that the applicant is a lady, this court is inclined to grant the privilege of interim period bail till the receipt of the case diary. Accordingly, it is provided that in the event of arrest of the applicant in connection with case number so and so, she shall be released on interim period bail on her executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned, to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Okay.
8 hours.
28. Okay.
Deeply obliged, my lordship.
Wait, please, Your Lordship. My lord, it is a petition for transfer of a criminal case, my lord, from the Court of Principal Magistrate Juvenile Justice Board, Silchar, to Morigaon, my lord.
Where the occurrence took place?
Occurrence took place at Silchar, my lord.
Silchar.
At
And
that
why
time-
you were
At
choosing
that time, my
Morigaon?
lord, the petitioner before your lordship was a 17 years old boy. And what happened, he went there for a labor, my lord. Now what happened, my lord, this case is filed against him by a guard as it about 21 years. And case was registered. Now, my lord, my humble submission before your lordship, Silchar is 317 kilometers away from Morigaon. And my lord, one person if visit there, my lord, it takes about 2,500 rupees to and fro journey and hotel stay. And I cannot go alone, my lord. I'm a tender aged boy, my lord. So I am to incur
No, you
rupees
can,
5,000
you can go
5,000 in
there
each
for
journey,
walking.
my lord. 5,000 in each
And
journey.
you
I'm a
cannot
tender
go
aged
there
boy, my lord.
for
Where
facing
my
the trial.
collect this money, my lord. My lord.
You can go there for walking.
My
And
lord.
you cannot go there for
No, my lord.
facing the trial.
My humble submission before your lordship, I went there. I have been taken by somebody to work in a brick mill, my lord. Brick mill. So there happened, what happened, my lord? Actual thing is this, my lord. Nature of work was very hard. That is why, my lord, I want to escape from that work. And ultimately, this case has been filed against me falsely. Now, my lord, my humble submission before your lordship, how I will incur this amount, my lord, and go to Silchar. Now, question will arise, your lordship, that how these people will come here.
Yes.
So, my lord, witness will come here. If your lordship please to transfer the case, in that case, my lord, government will incur the cost of the witnesses, traveling journey and fooding, etc. So, my lord, my hardship is this: nobody will take care of mine. They are to come, no doubt. This victim, alleged victim is to come, inform that some witness is to come. My lord, they will given payment by the government, but I will not be taken care of by the government. How I will go? And ultimate result will be that there will be no trial at all. Ultimately, I will be put in jail. Because, my lord, I cannot go. Because I do not have that money. That every time, and there I am to pay the advocate's fees also. And Morigaon is my near place, my lord. My district, original district. Juvenile Justice Board court is there also in Morigaon, my lord. No problem will create to the government, my lord, if it is transferred. Only once that IO is to come, my lord. And IO is visiting this High Court even day after day, my lord. That is the main problem. Ultimately, again, I will be put to jail. At that time, I was 17 years old boy, my lord. And the girl alleged that I am 21 years. And then someone wrong was done.
No, no, your interest and the interest of the victim has to be balanced.
My lord.
Hmm.
My lord, victim will come, my lord, and she will be paid
Mhm.
cost by the government. She is witness now. If some other witness is to come, mainly victim, my lord, then they will be paid by the government.
You have not arrived the victim as a party here.
Yes, my
My lord.
victim was not made.
Okay,
Heard
victim, my
Mr.
lord.
MSek, learned counsel for the petitioner, and Mr. P. Borthakur, learned additional PP for the state respondent. This application under section 447 of the BNSS 2023 is preferred by accused Merazul Islam for transferring JR case number 114/2025 CNR ASCC03 -00559 -2028 under section 319 within bracket 2, 64 within bracket 1, 115 within bracket 2 of BNS pending before the Court of Learned Principal Magistrate Juvenile Justice Board, Kasar, Silchar. Where is the petition and the documents placed on record? It appears that the informant cum victim has not been arraigned as a party in this petition. In order to dispose of this petition, arraying of the victim and the informant as a respondent number 2 in this petition is very much necessary, and accordingly, it is provided that the victim be arraigned as respondent number 2 in this petition, and notice be issued to her returnable in 4 weeks. Step be taken by speed post and also by Borthakur, the victim is a measure.
My lord,
It will-
may I submit one thing, my lord?
Yes.
My lord, is this criminal prosecution, my lord, in between government and the petitioner? Now, my lord, I humbly submit it is to be considered by your lordship that if victim is made party, from Silchar she is to come. Main thing is this, my lord, whether government will permit. It is the interest of the government.
We'll say, but we have
If
to
I
issue
made her
notice.
party, yes, my lord, if I made her party,
Hmm.
I think about this, my lord. If made her party, my lord, she is to come to Gauhati again
Yes.
to appear in the case. Anyhow, my lord, if your
Uh,
lordship deems it fit, I will make her
Issue
party.
notice by speed post and also by usual process within a week from today. List the matter after 4 weeks.
My lord. My lord, I am to made her party.
Yes,
Oblige, your lordship.
sir. And you have also to take step upon her.
My lord.
You have to take step upon her.
My lord.
May I please, your lordship?
Mr. MSC, learned counsel for the petitioner shall also file amended cost item before next date. Yes,
May I please, your lordship? Email revision will be against the water data 6/2026 lordship passed by the learned GMC Qatar lordship. Otherwise, the petitioner was filed Jimma regarding 15 number of cattle which was seized in
One report I have received from the.
Kindly say, page 63 is the impound order lordship. The petitioner lordship, the one Nitendra who is the registered certificate holder of for trading of cattle lordship. He authorized the present petitioner to purchase the cattle. The lordship. Kindly see the page 63 lordship impound order. When the registration certificate lordship, thereafter when the cattle was transferred lordship as per cattle SOP lordship, the both the cattle lordship fitness certificate, the transit certificate also issued by the veterinary officer lordship. I have an next lordship, and there is all total 16 number of cattle was purchased by the petition. Out of 16, 15 was a transport lordship. Through lordship, and out of 9, 6 number of and 9 number of cattle purchased from on Shahabuddin Lordship, and 7 number of cattle from one Holilur Rahman Lordship. They purchased the check from Lordship. I've annexed all the receipt Lordship.
When the occurrence took place,
Occurrence of the 14 Lordship, 14/5 Lordship.
14/5.
Lordship.
And when this power of attorney was given to you,
Subsequent Lordship.
subsequent.
Authorized letter, the subsequent after that Lordship, before sees the better. Kindly see the authorized letter, Lordship. Authorized letter, that is page Lordship. Page 46 Lordship. Author power of attorney given because to file the present case.
Yes, so what is the report, Mr. Borthakur?
Otherwise, report is, whatever the order trial court has earlier passed, trial petition of this earlier order, that at the time of submission of all those from the documents, those were submitted, from that documents, ownership could not be started at that point of time. And regarding the, the capital, otherwise, only on the basis of that rejection order, he has submitted this report. So, my lord, thereafter, what verification, further verification, if anything, because something more needs to be done.
No, at what stage the case is pending? Investigation or search it submitted?
Investigation.
Investigation.
Yes,
Better you produce the case, then we will see.
Lordship, kindly see the Lordship. I have all annexed all these documents, Lordship. Here's a register certificate, Lordship. Kindly see page 16, Lordship. And
No, let the CD come or we will consider your documents.
The
We'll see the stage of investigation.
already Lordship, from since 14/5/2026, cattle was under the custody of.
No, you say
His
the occurrence took place in the month of May.
Lordship.
Your power of attorney is in the month of June.
No, Lordship, the authorized letter, Lordship, kindly see, Lordship, for page 46, Lordship.
We'll say let the CD come.
Updated.
Updated case diary. Heard Mr. B. Islam, learned counsel for the petitioner, Mr. P. Borthakur, learned additional PP for the state respondent. Mr. Borthakur, pursuant to the order dated 29/7/2026, has produced one report from the ASI of police. It is from investigating officer.
Yes, sir.
From the investigating officer of Borkala PS. After going through the record and also going through the documents enclosed with this petition, perusal of the case that is found to be necessary, and accordingly it is provided that Mr. Borthakur shall produce the updated case diary before this court on 13th of August.
PS case number 20.
Scan copy, Lordship.
CD,
Scan copy of CD, Lordship. Then,
original CD. Okay.
then 13/8, Lordship. 13/8.
13th.
13/8.
13th.
17.
Long date, Lordship. Already, Lordship.
Let us try on 13. If not, then 7.
Please, your lordship, sorry to bother lordship, but there is something wrong in the pagination. Actually, they filed it in the Itanagar bench format where they put the translated copies below, my lord. Could I just compare with the court's brief, my lord? Could this matter be taken up just after some time, my lord?
Okay.
My lord, matter may be taken after some time, my lord.
Who will appear?
Mr. ARV, sir.
Item 13.
May I please, your lordship?
Yes.
Here in this case, lordship, petitioner was convicted under section 138 of NIF and subsequently she filed an appeal to Buddha. Appeal first appellate court session judge, and session judge, additional session judge by the order dated lordship may turn to page number 93. Operative part is in 95, lordship. 95 page number. Fifth paragraph. Considering that the appeal is admitted for hearing and the accused appellant is on bail, the operation of the sentence of imprisonment and fine awarded by the imperial judgment in order it is so and so, passed by the learned JMFC so and so, in an NIA case so and so, is hereby stayed till disposal of this appeal, and the accused convict is allowed to remain on previous bail subject to the following condition, that the accused convict shall deposit in court an amount of about 20% of the fine awarded by the learned court under section 148 NIA, which would be rupees 11,26,000 within a period of 60 days from today. Subsequent thereto, Lordship, we have filed an application for waiver for waiving that 20% amount. It is in case number 97, and court did not consider our prayer, Lordship. So,
No, this is a statutory provision
Lordship,
148 NI Act.
yes, Lordship.
So what wrong with this order?
There is no wrong,
It
Lordship.
is a discretionary power.
Yes, Lordship, this is the
The
discretionary power.
appellate court has exercised the discretion.
Yes, Lordship. In Jambu Bhandari case, Lordship, I would rely on this judgment of this apex court, Lordship. In
What is the
Jambu Bhandari,
ratio of that case?
Lordship. In Lordship. In paragraph 6, Lordship. Paragraph 6, Lordship, it is stated that what is held by this court is that purposive interpretation should be made section 148 of the NIA, hence normally appellate court will be justified in imposing the condition of deposit as provided section 148. It is justified. However, in a case where the appellant court is satisfied that the condition of deposit of 20% will be unjust, or imposing such a condition will amount to deprivation of the right of the appeal of the appellant, exception can be made for the reasons specifically recorded, Lordship. The subsequent order.
So what exception you have made out here?
Yes, Lordship, in our application, we have stated several grounds, Lordship, that were not considered. First of all, Lordship.
Where is the application?
Application is page number 97, Lordship. Operative part 98, Lordship, paragraph 3, the grounds. That the petitioner has preferred this instead petition for paying for indulgence of this court, unable to waive, reduce the said deposit, keeping in view of the following grounds. Number one, lack of prima facie case, that the complainant filed the respondent lacks merit. The complainant failed to establish any legally enforceable debt which was not properly considered by the learned court below. The complainant in her evidence in affidavit and cross-examination made self-contradictory statement regarding any legally enforceable debt, but the learned court overlooked it and passed the impugned judgment. This contention can only be established after a full trial adjudication of the appeal, Lordship. Then thereafter, Lordship, another point, financial hardship, that the petitioner is currently facing severe financial constraints. The business of the petitioner is undergoing tremendous setback. Therefore, depositing a minimum of 20% of the claim amount at this interim state would cause irreparable harm and suffering of the petitioner without adjudication. And it will also be an unjust burden that since the alleged transaction and the disputed check amount itself are in severe contention, demanding a substantial deposit on a presumptuous amount.
Okay, let notice go today.
Lordship.
Let the other side appear. We will hear the matter. Heard, Mr.
K.K. Henry, Lordship.
Learned counsel for the petitioner. And also heard. State is not a party. Also hard to cut it. The order dated 16/5/2026 passed by the learned additional sessions as FTC Barpeta in criminal appeal number 36 of 2026, directing the petitioner to deposit 20% of the fine amount within 60 days. within 60 days of the order dated 16/5/2026 is challenged in this petition under section 528 of the BNSS 2023. Peruse the petition and the documents placed on record and also peruse the impugned order dated 16/5/2026. The learned counsel for the petitioner, referring to a decision of Honorable Supreme Court in the case of Jambu Bhandari versus MP State Industrial Development Corporation Limited and others, reported in 2023 0 Supreme within bracket SC. No, take down the SCC. 2023 10 SCC page number 446. Submits that purposive interpretation should be made to section 148 of the NI Act. And normally appellate court will be justified in imposing the condition of deposit as provided in section 148. However, in any case, the appellate court is satisfied that the condition of deposit of 20% will be unjust, and imposing such condition will amount to depriving of the right of the appeal of the appellant, exception can be made out for the reason specifically recorded. And he also submits that in the application file before the learned trial court, no, appellate court, the appellant herein has made out the exceptions, but the same has failed to evoke any response from the learned appellate court. And in that view of the matter, he has contended to allow this petition. The submission of learned counsel for the petitioner needs further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Place the matter on fixed date. Sort date. September, okay.
What if till returnable date?
Will not grant any stay.
Deeply obliged. Deeply obliged.
May I please, the Lord? My Lord, in this case, the respondent number 2 is the former wife of the petitioner, my Lord. She filed an application under section 125 CRPC seeking maintenance of her children, my Lord, 2 children, my Lord. Your Lordship will find page 13, my Lord. Page 13, judgment started and operative part, my Lord, page 19, my Lord. In view of the above discussion,
So the trial court has directed you to pay maintenance
maintenance, my Lord.
at the rate of rupees
1300, 2 children, it is total 2600 per month, my Lord.
2,600.
600.
And you have preferred revision.
No, my Lord. Then she filed a petition seeking enhancement of the maintenance, my Lord.
Before the
Same court, my Lord. Enhancement under section 127, my Lord.
Yeah.
Then, my Lord, the learned trial court enhanced the amount to rupees 7,000, my Lord.
7,000.
7,000 from
Yes.
2,600 to 7,000, my Lord. Then, my Lord, petitioner preferred a revision petition, my Lord. And revision petition, the learned revisional court reduced the amount to rupees 6,000, my Lord.
Hmm.
7,000.
Against that order, you have been preferring this present petition.
Yes, my Lord. My Lord, my humble submission at this stage, some amount has become arrear, my Lord, by calculating rupees 6,000, my Lord, in the meantime, my Lord. So, my Lord, in the meantime, notice may be issued and some relief, suppose 4,000 petitioner is also ready to pay the amount, my Lord. If 4,000 he is directed to pay 4,000, my Lord, till disposal of this petition, my Lord.
No, whether 4,000 will be justified. What is the age of the children?
My Lord, age of the children, my Lord, almost they are going to attain the majority, my Lord.
Majority.
Yes, my Lord.
So whether this whether 4,000 will be sufficient for three persons?
No, my 2 person, my lord. My lord, a wife has already got divorced, my lord, and she has no. My lord, your lordship will find page.
No, are they not studying now?
My lord, page 18, my lord.
No, whether the children are studying now?
My lord, she herself admitted in a English medium school, but status does not. My lord, petitioner is a vendor, my lord, stamp vendor, my lord. He on her own, my lord, admitted in a
Let
English-
notice go at this is this on next date we'll see.
my lord, my humble submission.
But till then you make payment of the amount.
My lord,
Heard
petitioner is
Mr. H.M.R. A.H.M.R. Soduri, Learned Counsel for the petitioner. Mr. Borthakur for the respondent number 1. Judgment dated 17/5/2024 passed by the Learned Additional Session Judge Hailakandi in Criminal Revision number 27 of 2024 is being challenged in this petition under section 528 of the BNSS 2023. It is to be noted here that by the impugned order dated impugned judgment dated 17/5/2024 in Criminal Revision number 27 of 2024, the Learned Session Judge has affirmed the order dated 18/1/2024 passed by the Learned Judicial Magistrate First Class Hailakandi in Miskis number 8 of 2019. Enhancing the monthly maintenance from rupees 2,600 to rupees 7,000, has been modified and reduced to rupees 6,000 per month. Peruse the petition and the documents placed on record. Let notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. A SSL call for the scan copy of the record from the Learned Additional Session Judge Hailakandi in Criminal Revision number 27 of 2024 and also the scan copy of Miskis number 08 of 2019 from the Court of Learned Judicial Magistrate First Class Hailakandi. List the matter. After 4 weeks, interim pair of the petitioner will be considered on appearance of the respondent number 2 herein.
My lord, may
And also on receipt of records from the learned courts below.
my lord, next date fixed 28, my lord, and my lord, if petitioner is ready to pay, my lord, some amount, my lord, if he is unable.
No,
to pay,
you
my lord,
continue to pay 6,000. On next that interim pair of the petitioner will be considered on receipt of the record from the learned court below and also on appearance of the respondent number 2.
My lord, then a date may be fixed, my lord, date may.
Okay.
Obliged.
Please, all of it's a petition against the impugned order dated 2026, my lord, framing charges against the petitioners, my lord. My lord, let me come to the FIR for a moment, my lord, at page 21. With due respect, I wish to state that I, Srimati so-and-so, resident of so-and-so, I beg to inform you that today at around 3:30 p.m., a resident of Silapathar, Madhavi Pathar, namely Dev Chetri, and a resident of Itanagar, namely so-and-so, both suddenly entered my residence with an iron rod and tried to attack my husband while sitting without any reason with an intention to kill him. As they attempted to kill, I shouted and they attacked me and tried to rape me. When I shouted loudly, the local villagers came and rescued me and my husband, Deepak Luitel, from these two monsters. Upon seeing the villagers approach, the aforementioned attackers fled away. Therefore, I request counsel. Now, my lord may come to their statement. This is the statement of the of respondent number 2, the FIR informant, who is the wife. Now, the statement, my lord, of the husband is at page 33, my lord. Sorry, my lord, page 31. My
Yeah.
name and address are as above. I am a businessman. I have known so and so for about 25 years. I'm avoiding the name, my lord, for reasons.
Mm.
We had friendly relationship. He used to visit our house frequently. Everything was good amongst us. However, on last October, during the time of Durga Puja, my wife told me that he spoke ill or bad against me, and we had a quarrel over phone regarding why he spoke ill or bad against me to my wife. Thereafter, my wife told him not to come to our house. Thereafter, he did not come to our house. However, suddenly on 5/4/2025, he, along with Dev Chetri and Dev Chetri's wife, came to our house without informing us while I was asleep in my bedroom. So-and-so attacked me, so-and-so covered my mouth, the same person, and hit a blow on my injured left hand. I shouted for help. When my wife was doing work outside, came running to help me, came in between us. So-and-so said, "Get out of here," and threw her and tore her clothes. Then she shouted and local villagers came out. And after seeing people, so-and-so and Dev Chetri, who came along with him and his wife, fled away from there. So this is a development, my lord, that they fled away. And while he was sleeping in his bedroom, his mouth was covered and hit with a rod. Now, my lord, the informant statement, my lord, 180 statement, my lord, page 33, my lord. I want to state that I know so-and-so and Dev Chetri for about 23 years as friends of my husband. They usually come to our house and eat. Our relationship was good till last October. However, since last Durga Puja, our relationship broke as so-and-so spoke bad about my husband. And therefore, on the day of Navami of last Durga Puja in October, I told him not to come to our house. He told me to leave my husband. Therefore, we had quarrel amongst us. Thereafter, he never came to our house. However, on 5/4/25 at about 3:30 p.m., so-and-so and Dev Chetri and his wife came to our house without informing. They directly came to my bedroom and attacked my husband. After hearing my husband shouting, I came from outside where I was doing work and saw a piece of cloth inserted in my husband's mouth. And so-and-so tried to give a blow to my husband, and my husband tried to stop him with his hand. When I came in between them to calm down the quarrel, so-and-so threw me and tore my clothes, attacked me. When I shouted, hearing my hue and cry, villagers of the people walking by the road came, and after seeing people coming, they ran away from our house in their vehicle. My lord, the two statements of the witnesses, my lord, page 35, my lord. A totally different story, the prosecution witnesses. Page 35, this is of Anil Dow. I know Sri Deepak Luitel on 5/4/2025 at approximately 3 p.m. to 4 p.m. I don't remember the exact time. I was standing in the road in front of Deepak Luitel's house and speaking to some of the villagers. Then I saw some people and Deepak Luitel, along with family, were having a quarrel at the courtyard of their house. Then we went to their house to see what was happening. There were many people of the neighboring village and 2 more people from outside were there. There were 3 people who came from outside, 2 male and 1 female. That is the petitioners and the petitioner number 1's wife. Deepak Luitel and his wife were quarreling with them for some reason. We tried to stop them, saying, why you need to quarrel? But suddenly one man from the side of Deepak took one stick and hit one man who came from outside. That is the petitioner number 2 here. As a result, the head of the person broke, and after seeing that his injury was severe, one person from amongst them, namely Khukon Pait, tied the head of that person with the dupatta of a lady who came with them and asked him to leave. I have not seen those people hitting Deepak. It's biting when it's typographical, it should be hitting. This is all I have to say. The others witness, my lord. Page 36, my lord, Khukon Pait. The name and address above are true. I state that I know Deepak Luitel. My residence is by the other side of the road of Deepak's house. On 5/4/25 at 3 p.m., I was standing on the road in front of my house. At that time, I saw a fight was taking place in the courtyard of Deepak Luitel's house. It's Kazia, that's why they translated as fight. It should be quarrel, my lord. I came to their house to see what quarrel was going on. Many people from the village was there to see what was happening. There were 3 people from outside at the courtyard of Deepak Luitel's house, not in the bedroom. One of those three persons was an advocate and another was advocate's friend and friend's wife. Deepak Luitel and his wife were having quarrel for some reason with them. I know the advocate and his friend and his wife. Earlier, they used to visit Deepak Luitel's house. Then I met them. When we saw the quarreling, we stopped them saying, why should you should quarrel? But suddenly one man from the side of Deepak came with a stick and hit the advocate. As a result, the head of the advocate broke and sustained injury in different parts of the body. I tied the head of the advocate with the dupatta of his friend's wife and told them to go from here. I do not know the person who hit the advocate. I have not seen the advocate and the persons coming with him from entering the house of Deepak. My lord, this is a cross FIR actually. Now, my lord may turn to the next page, page 37. There's a photograph which is there in the case diary, which is given to us along with the charge sheet, my lord, along with the documents, my lord. My lord, we'll see the note just above the photograph. It is to be noted that on arriving at PO, a rough sketch map of the PO is drawn by me, as shown by the complainant, that while visiting PO, the complainant showed a photograph which was taken on the date of occurrence where the accused persons were standing outside her house and a few persons were standing behind them. Photograph is attached herewith. Number one is the FIR named accused so-and-so, my lord. I'm avoiding the name, my lord. Number two is Dev Chetri. 3 and 4 are the witnesses mentioned below. Then below the photograph, from the complainant, it is learned that the persons standing behind the accused are persons from neighboring village. Therefore, I collected the name of 2 witnesses marked as 3 and 4. They are found available. So 1 and 2 are the petitioners here. Accused number 1 is petitioner number 2. And the numbering there in the photograph, my lord. 2 is petitioner number 1. 3 and 4 are the witnesses. Everything was in the courtyard. When accused, the petitioner number 2, herein marked as 1, my lord, in the photograph, he was attacked. He lodged an FIR. He had to have 7 stitches on his head. And my lord, this was actually, I have stated so, this was actually, we should not take up cases of persons known to us. He had advised them on a matrimonial dispute between them. Thereafter, the husband started scolding him. And he went, it went to such an extent, it's in the statements of Dev Chetri, the other. If my lord goes through, it will be clear. My lord, because of the scolding from on numerous occasions over phone, my lord actual abuse, my lord, of this petitioner number 2. He had gone,
Mr. Nair,
my lord.
see, whether from perusal of the statement of the informant
My lord.
and her husband,
My lord.
it cannot be said that no prima facie case is made out for framing search.
My lord, the witnesses relied on by the prosecution, my lord. They are named in the charge sheet, my lord. The witnesses, they do not say that this thing has actually happened. This is a cross case, my lord. And in the cross
No,
case,
maybe.
my lord.
Therefore, I am asking you
My
whether the evidence of the statement of the informant and her husband is not sufficient.
My lord, it will not be sufficient because the trial court, my lord, at the time of framing of charge, has to see whether it is probable or not, whether there is suspicion or grave suspicion. If there are 2 sides of the story, if 2 views are probable, my lord, there are judgments to that effect, my lord. If the 2 views are, probably my lord knows, if 2 views are possible, then the benefit has to go to the accused at the time of framing of charge.
Benefit, that benefit you are asking for will be considered at the end of trial.
My lord,
But at the time of framing of search, only the prima facie case.
My lord, that grave suspicion is not here, my lord, because the witnesses relied on by them, they say that this incident has not taken place at all. Rather, they say, I am the victim. And my lord, there is no
at that time, a meticulous examination of the materials on record is not required.
My lord, the perusal of the materials which are there with the CD, they have to be
Okay,
examined.
let notice go at this instance.
My lord, the matter is fixed on 12th, my lord.
Maybe.
My lord, some protection, my lord.
No.
My lord, if it is not stayed, my lord.
No.
Well, unnecessarily, I'll be, because ultimately it is apparent, my lord, because they are accused, the complainant and his husband, my lord, they are accused in the cross case. I have annexed that charge sheet itself. And charges have been framed. That order framing charge, my lord, is at page 56, my lord. It has been framed, orders, my lord, charges have been framed against them. Well, these 2 cases, my lord, they are totally contradictory to one another. One must be false, my lord. And from the materials available here, my lord, along with the charge sheet, they show that the case against the petitioners herein is false. It is actually a malicious prosecution to save them from the FIR against them.
No, that kind of opinion cannot be formed at this instance. Okay.
My lord, of
Heard
the material.
Mr. Nair, learned senior counsel assisted by Mr.
S. Rana.
Learned counsel for the petition. Mr. Thakur, learned additional PP for the state respondent number 1. The order dated 28/6/2026 passed by the learned additional Chief Judicial Magistrate Dhemaji, framing charge under section 329 within bracket 4, 115 within bracket 2, 74 and 3 within bracket 5 of the BNS 2023 is challenged in this petition under section 438 reduced section 528 of the BNSS 2023. It is to be noted here that by the impugn order dated so and so, the learned additional Chief Judicial Magistrate has framed charge against the petitioner's hearing under section 329 within bracket 4, 115 within bracket 2, 74 and 3 within bracket 5 of the BNS 2023 and issued summon to the witnesses. Peruse the petition and documents placed on record and also peruse the impugn order dated 28/6/2026. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Thakur entered appearance and received notice. But extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 and 3 be taken by speed post and also by usual process within a week from today. Rest shall call for the scanned copy of the record from the learned trial court. Interim period of the petitioner will be considered on next returnable date.
Mine. Deeply obliged. Item 16. The date, my lord. Next. My lord. Deeply obliged. Item 16.
May please order. Petitioner was convicted in a complaint case under section 130 of NI Act, my lord. And he was sentenced to pay some 5,50,000. Then appeal was preferred before the one session judgment. Appeal was admitted and the judgment was stayed. What happened, my lord? The appellate court directed to pay the 20% of the check amount, my lord, the sentence amount. Kindly see the order, my lord, page.
So what wrong with that order? There is a
There is
provision.
nothing wrong, my lord. There is nothing wrong, my lord.
Pardon?
There is nothing wrong, my lord.
Yes.
Petitioner be directed to pay the 20%, my lord. But the petitioner failed, my lord. On being failed, my lord, you'll also kindly see the order, my lord, last impugn order, my lord, page 52. The order of suspension of sentence, my lord, and the, my lord, bail was recalled, my lord. Page 53, my lord, the operative portion. The failure is because of the fact that the petitioner was suffering from some illness. That's why he failed to pay, and there was financial constraint. Now the petitioner is ready to pay the entire amount. The 20% of amount as directed. So I'm ready to pay the amount. Lordship may dispose of the petition, directing the appellate court to accept my amount. There is nothing wrong in the order.
Heard Mr. P.J. Soikia, learned counsel for the petition. order dated 22nd of April 2026, passed by the learned additional session Joseph Sagar in criminal appeal number 02, written bracket 1 of 2026, is challenged in this petition under section 528 of the BNSS 2023. It is to be noted here that by the interim order dated 22nd of April 2026, the learned appellate court has vacated the stay
Yes.
order. No, state vacated the order dated 12/1/2026.
And also the
And
calling,
in state
recalling
the
the fellow.
operation of the sentence and order dated 29/12/2025, passed in NI case number 26 of 2023 by the learned Aziz M. Nazira, and also cancel the bail of the appellant,
Appellant petition.
the petitioner hearing. Mr. Soikia, learned counsel for the petitioner, submits that the petitioner was an accused in NI case number 26 of 2023. And he stood convicted in the said case by the learned Aziz M. Nazira and sentenced him to suffer imprisonment for
Well, only payment, direction of payment,
sentence him to
pay the
where is that order?
page 43. With default section. Paragraph 52.
Sentence to pay the said amount of rupees 3,50,000 and also a sum of rupees 2 lakhs, total 5,50,000
Yes.
to the complainant Rajan Sahu, and also impose a fine of rupees fine along with compensation of rupees 40,000 with a default stipulation. And being agreed by the said judgment and order of the learned subdivisional judicial magistrate M. Nazira Sipsagar, the petitioner herein has preferred an appeal, being criminal appeal number 02, which will make it 1 of 2026. And while admitting the appeal, the learned appellate court has stayed the operation of the sentence and order dated 29, sentence and order dated 29/12/2025, passed in NS number 26 of 2023. By order dated 12/1/2026 and allow the appellant to remain on previous bail
Yes.
on the condition that he will deposit 20% of the fine amount of rupees 5,000, 5,50,000 within a period of, as mandated by section 148 of the NI Act, within a period of
90 days.
90 days.
Yes.
Within a period of 90 days. And Mr. Soikia further submits that on account of his illness, the petitioner could not deposit the 20% of the amount. And therefore, he has filed one application, being application number 325 of 2026 for further extension of time. But the learned trial court, appellate court has dismissed the same and also cancel the previous bail of the petitioner. Mr. Soikia further submits that the petitioner is ready to pay the 20% of the amount
Well,
before the learned appellate court. And as such, he has contended to allow this petition by directing the petitioner to deposit the 20% of the amount, and also by directing the learned appellate court to allow him to remain on previous bail. Para, taking note of the submission of learned counsel for the petitioner, this court is inclined to dispose of this petition by directing. Having hard to dispose of this petition by directing the petitioner herein to deposit 20% of the fine amount before the learned appellate court or trial court?
appellate court,
Appellate court on or before
any date, Your Lordship, Monday or Tuesday, my lord.
14th. And on such deposit being made by the petitioner herein, the learned appellate court shall allow the petitioner to remain on previous bail, and also shall suspend the sentence.
Yes.
Suspend the sentence till disposal of the criminal appeal number 02/1 of 2026. In terms of above, this criminal petition stands disposal.
Obliged.
May I please, Your Lordship?
Hmm.
My lord, the matter relates to Jimma of a vehicle, my lord. The petitioner is a registered owner of a my lord truck which had been my lord seized pertaining to an NDPS case, my lord. And the order which we have impugned, my lord may be pleased to find is that page, my lord. My lord, it starts at Annex 5 at page 58 and the operative part, my lord. Starting at page 61, my lord. Paragraph 7, my lord. Considering, may I read, my lord? Considering that the seized psychotropic substance was found concealed in the seized truck, and also considering the fact that the said truck being to the accused Sri so and his prima facie charged with the commission of the offense under section so and so of the NDPS Act, the prayer for the Jimma of the seized truck is rejected at this stage because the seized truck may be liable for confiscation, and also because the seized truck would be required during the trial of the case, as it would provide adequate evidence because the truck was used to conceal the contraband. Now, my lord, this confiscated amount, a seized amount of rupees 44,860, my lord, the interim Jimma had also been rejected. Now, my lord, here in the instant case, my lord, I have, my lord, gone through the relevant provisions, my lord, of the NDPS Act, which, my lord, starts the section 63, my lord. Procedure for making confiscation. In the trial, may I read, my lord? Section
Yes.
63, subsection 1. In the trial of offense under this act, whether the accused is convicted or acquitted or discharged, the court shall decide whether any article or thing seized under this act is liable to confiscation under section 60 or 61 or 62, and if it decides that the article is so liable, it may order confiscation accordingly. So, my lord, if we go through the provision of this, my lord, section, the condition which has been provided that, first of all, my lord, the accused is required to be convicted or acquitted or discharged. Now we are in a stage, my lord, the charge sheet has been filed. The trial has not yet been commenced. So, my lord, therefore, neither of these three conditions is in force. So, my lord, therefore, my lord, arriving at a presumption by the learned trial court below that the matter may be confiscated, it will come after the conclusion of the trial, my lord. This law has already been discussed by, my lord, by this honorable court also. If my lord may be pleased to take up one of the order, my lord. Proceed. Lord, the long order, my lord, can skip and the operative part, the discussion which has been made, my lord.
No,
Mal-
Mr.
Mal-
Bhuyan,
My lord.
there is a very recent decision of Supreme Court.
Yes,
Mal-
India versus State of Assam.
State of
Court
Assam.
has
Mal-
You please go through the same, whether, and you submit before this court on next date, whether
My-
that decision will help you or
That
not.
covers or not, my lord.
Yes.
Yes, my lord. A short
Heard-
date may kindly be
Heard,
given.
Mr. A.R. Bhuyan, learned counsel for the petition. In this petition under section 528. No, 438, read with section 442 of the BNSS 2023. The petitioner has challenged the order dated 38/5/2026 passed by the learned Special Judge Karbi Anglong. Defu in Jimma petition number 49 of 2026 arising out of Khotkhoti PS case number 10 of 2026. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the petitioner seeking custody of the seized track of his seized track bearing registration number PB 65
Yes. AN
AN-1277 and case rupees 44,860. Where is the petition and the documents placed on record? List the matter on next week.
Next Tuesday, my lord.
Thursday for
Mal.
further consideration.
Yes.
You take the
Yes,
citation
yes,
from
my lord.
him.
Mal. Oblige, deeply oblige.
May I please, my lord? My lord, this criminal petition has been filed for cancellation of the NBW, my lord, dated 3/2/2020.
Where is the order?
My lord, your lordship kindly see order,
Page number
page number 37, my lord,
30.
37, my lord. My lord, in fact, my lord, no summon was served upon the accused. My lord, what happened, my lord? Accused, our present accused, remaining.
Who is the petitioner herein?
My lord, Rafiqul Islam, my lord.
Rafiqul Islam.
Page 37, my lord.
Otakur, what to do?
My lord, one submission before your lordship, my lord.
Mm.
My lord, pursuant to an FIR, my lord, what happened, my lord? Pursuant to an FIR, my lord, 4 accused are arrested. And the present petitioner, he was sent to the jail.
When the next date is fixed?
Next date, my lord, your lordship kindly see page 48, my lord, 1/10/2026, my lord. My submission, my lord, someone was not served, my lord, upon any point of time, my lord. My lord, I am in fact, my lord, I am ready, my lord. Other accused person also is appearing, my lord. And my lord, only because of this NBW, my lord, I am apprehending, my lord, arrest. My lord. My lord, in fact, your lordship kindly see page, my lord, 29, my lord. 29, my lord. May I read, my lord?
Not necessary. Okay, on that day you appear
My lord, I
before
will
the
appear
trial
with-
court?
My lord, I will appear within 10 days, my lord, in the within 10 days I will appear, my lord. My lord, I may be allowed to remain on previous bail, my lord. In fact, my lord, I was sent to the jail, my lord, during police investigation, my lord. And after 20 days, I was released. I was granted bail by the.
No, you go in and apply for regular bail there.
My lord, in fact, my lord, someone was not sharp upon me, my lord. This is the clear fact. my lord.
Maybe some of the accused person have been appearing there. When Hasmat Ali, he has been appearing there.
My lord, page
You
29.
belongs to the same list of Abdul Mannan, Abbas Ali and Hasmat Ali.
I am Rafiqul, my lord. I am Rafiqul, my lord.
You belongs to the same list?
No, my lord. No, my lord. I am. I belong, my lord. Village Larkusi, my lord. Nalbari district, my lord.
And these persons belonging to which place?
My lord. This person, my lord. There are some different in writing in address, my lord. Some, due to some difficulties, my lord, I was not summoned, my lord. Once time,
So it means that you have not given the proper address to police.
no, my lord, my lord, your lordship kindly see the search sheet, my lord.
The page 17, name and address of.
Okay, let us not go through the same.
My lord,
You go and apply for regular bail there. The trial court will consider the same. Heard, Mister?
considering, my lord, unserved summon, my lord, and none.
Heard, Mister?
Manna.
Learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, read with article 227 of the Constitution of India, the petitioner has challenged the order dated 3/2/2023
And
passed by
subsequent.
the learned
subsequent
chief
other-
judicial.
And subsequent.
Please sit down. Please sit down. Challenge the order dated 3rd February 2023 and all subsequent orders passed by the learned chief judicial magistrate Kamrup M. Gauhati against the present petitioner in GR case number 8609 of 2014 arising out of Vasistha PS case number 708 of 2014 registered under section 379/34 IPC. The learned counsel for the petitioner submits that the petitioner herein was arrested during the course of investigation and he was remanded to Jail Hazard and subsequently he was enlarged on bail. And thereafter, the investigating officer has submitted charge sheet in the Vasistha PS case number 708 of 2014 and there no notice, no summon was served upon the petitioner herein, for which he could not appear before the learned Chief Judicial Magistrate Kamrup M, and for which by impugn order dated 3rd of February 2023, the learned Chief Judicial Magistrate Kamrup M has issued non-bailable warrant of arrest against the petitioner. The learned counsel for the accused further submits that he is ready to face trial and will appear before the learned trial court on each and every date, and therefore he has contended to set aside the impugn order dated 3/2/2023 and all subsequent orders by which non-bailable warrant of arrest was issued against the present petition. Mr. Borthakur learned additional PP submits that the petitioner may be directed to appear before the learned trial court and to apply for regular bail. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this petition stands allowed. By directing the petitioner to appear before the learned Chief Judicial Magistrate Kamrup M. Gauhati on or before on or before 24th of August 2026 and to apply for regular bail, and in the event of filing such an application, the learned Chief Judicial Magistrate shall consider the same in accordance with law. Till then, non-bailable warrant of arrest issued against the present petitioner by impugn order dated so and so and by all subsequent orders shall be kept in abeyance in terms of this petition is disposal. Okay. Yes.
May I please approach? So the petitioner is seeking quashing of the FIR registered under section 316 to 318(4)
and along with some non-cognizable sections also. The lordship will find the Ejahar at page 22. That's translated copy. May read out. Page 22.
Let notice go at this, sisters.
My lord. My lord, on the face of it, the allegations don't attract the sections, my lord.
Pardon?
On the face of the allegations, they
Hmm.
don't attract the sections, my lord.
So, okay, we will examine it. Let the record come.
My lord, kindly stay the investigation. The protection is required.
Such
They are
it is
already-
not
actually,
submitted.
This honorable court has.
Investigation
granted-
is going on.
My lord,
Investigation is going on.
yes, my lord.
Okay, Mr. Borthakur, then you produce the case diary. After perusing the case diary, we will consider your interim pair.
Kindly see on the face of it, they don't, this is purely civil dispute, money transactions, my lord. No intention is here. And also there is a recent judgment of the Supreme Court that both these sections, criminal breach of trust and TT cannot be invoked on the same sets of facts.
Okay, we will examine it.
Then a short date may be granted. in that case. For the consideration.
When Borthakur?
Interim.
From which place it will come?
No, no, Kachar district.
Kasar. Lakhipur. On 19th of August. 19th of August. Interim pair will be considered after perusing the case diary on next date.
Item 19.
Obliged.
Is an application under section 528 lawsuit, where the impugn order lawsuit, page 45 lawsuit. On the very first day lordship, NBW was issued lordship, without resorting the other mechanism.
Page number? Impugn order?
45 lordship.
45.
Yes, sir. So in the third paragraph, the accused person named is so and so are shown as absconder in the search sheet.
So,
Issue NBW against them.
Mr. Ahmed, there is a decision of this court.
Yes, but I have brought one decision lordship.
Yes.
Considering the Indramohan Goswami and others, on the very first day, it cannot be because it amount to interference of Article 21.
Heard Mr. A.Z. Ahmed, learned counsel for the petitioner. And Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 528 of the PNSS 2023, the petitioner has challenged the order dated 23rd 6 2026 passed by the learned additional chief judicial magistrate South Salmara Mankasar in connection with PRC case number 181 of 2026. It is to be noted here that by the impugn order dated so the learned trial court has issued non-violable warrant of arrest against the present petitioner. Mr. Ahmed, learned counsel for the petitioner, submits that the petitioner is an accused in PRC case number 181 of 2026. And in the said case, the investigating officer, after completion of investigation, has submitted search sheet, and upon the said search sheet by impugn order dated 23rd 6 2026, the learned tribunal trial court has taken cognizance of the offense, and as the present petitioner is shown as absconder in the search sheet, the learned trial court has issued non-bailable warrant of arrest against him. Mr. Ahmed, learned counsel for the petitioner submits that in view of the decision of Honorable Supreme Court in the case of Indar Mohan Goswami versus State of Uttarakhand, reported in 2007-12 SCC, page number 1. Page number 1. Non-bailable warrant of arrest cannot be issued on the basis, no, on the very first day, without issuing summons and bailable warrant of arrest to secure the attendance of the person, such person. As issuance of non-bailable warrant of arrest at the very first instance would impair the personal liberty of the petitioner. And as such, he submits that the impugned order is illegal and arbitrary, and it fails to withstand the legal scrutiny, and therefore he is contented to allow this petition. Mr. Borthakur, learned additional PP submits that. Yes, Borthakur?
Yes, madam.
We set aside the order, we direct him to appear before the trial
Set
court.
aside lordship because the law is settled lordship. Cannot be set aside lordship, my humble submission was.
No, we will set aside this order,
Yes,
but you have to appear there and to apply for regular bail.
sure. Sure.
Mr. Borthakur, learned additional PP submits that by setting aside the impugned order dated so and so, the petitioner herein may be directed to approach the learned trial court and to apply for regular bail. But accordingly, taking note of the submission of learned counsel for both the parties, and also in view of the decision of Honorable Supreme Court in the case of Indar Mohan Goswami, this court is inclined to dispose of this petition by setting aside the impugned order dated so and so. As the same failed to withstand the legal scrutiny in view of the proposition of law laid down in the case of Indar Mohan Goswami. However, the petitioner is directed to appear before the learned trial court on or before 24th August and to apply for regular bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law.
Hello.
It is your lordship.
Hmm.
My lord, here in this case, my lord will find the petitioner has lodged an FIR in Chanmari police station for commission of a cognizable offense against the accused persons, and that was received by them. GD&T was made, and subsequently we have been pursuing the matter, and then we come to know that the zero FIR has been registered and it has been transferred to Telangana and Hyderabad. Now your lordship will kindly examine under what circumstances, my lord, the zero FIR is to be registered and it is transferred to some other state, my lord.
I am from Bamani Meta.
Because I am from Assam, my lord. I am from Bamani Vedam. It is jurisdictional police station, and the offense has been committed here. Money has been received from here, and instead of registering a
Where
regular
is the impugned order?
impugned order, the FIR first your lordship will find the FIR at page, my lord, page 7 it is the FIR.
No.
And the zero
Mr.
FIR, my lord,
Kundri,
date
you
at
have,
page.
here you have challenged the order dated 15/5/2026. Where is that order?
Page 39, my lord.
Page 39.
And where is the FIR?
FIR at page 17.
Register করেছে
And zero FIR is 24. 24.
So what is the complaint?
And the reason given in page 27, that all the accused persons from Hyderabad and therefore, and their office is also from Hyderabad, and therefore it is to be transferred to Hyderabad. That is the only ground shown. And if that is so, then nobody can file an FIR in anywhere. We have seen, my lord, the offense is
Page
committed
number
in a particular
17 is the
jurisdiction.
complaint.
Is there the it's 17
Yes, page 27.
Who lost
That is
this
the ground.
complaint?
That the ground, my lord. Ground of transfer.
No, 17 Ezahardo says
So as my lord will find a page 17.
17. Job and education degree. Actually, from BGC, I come to know that they don't have any standard to it any university.
My lord, in fact, my lord, they have invited online application along with, my lord, some fees. And we have applied for, we have given the fee. And subsequently, we have come to know that the UGC has already given a notice to the accused person saying that whether you have got some collaboration with some universities. Because they say that they are having collaboration with 26 number of universities, and they are, my lord, leading this educational program, my lord, with a hope to get employment. That was the, and subsequently we have come to know that this is fake, all fake, my lord, all fraud. And they have collected money not only from me, my lord, from thousands of lakhs of people from India, my lord.
And because there is prima facie case, they have registered zero affairs.
And after going to the same, my lord, police has got the prima facie case and the commission of the particular various sections also, and that is why the zero FIR has been registered. And the different sections are also, my lord, will find at page 24. So right at this moment, I only, my lord, pray that
I can go to Telangana and
my lord, at this moment, my lord, it is transferred, my lord. As a student, can I go to Telangana and cooperate with the Telangana police? And ultimately, it is negate my whole claim.
I cannot pursue.
So, my lord, let them appear, my lord, and let them say. And you will also will lay some guideline also, because in Assam, we have found that normally some SOPs are also given by the DGP. And here in Assam, in other states, we have found, but in Assam, my lord, we have not found any.
Guidelines.
Subject to correction, my learned friend, my lord.
Yes, Mr. Bortakor.
Yes, regarding that SOP, I will have to look into it. But otherwise, from the contents of the FIR, there are some grounds in which, because of the entire offense, everything on those. But why that was. The report has to be mentioned.
Both the Telangana police are killed. But when I am there, some is enough. That is. Of the offense in Assam.
But if it doesn't, so we don't know what is the gist of it, that's what is the new affairs and the regular affairs. Yeah.
Okay. Heard Mr. Chaudhary, learned counsel for the petitioner. No, learned senior counsel for the petitioner, assisted by Mr.
MK Chaudhary.
And also heard Mr. Bordhakur, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 15/5/2026 passed by the inquiry officer before the Assistant Commissioner of Police Sanmari Division, seeking approval for registration of the case as a zero FIR, and also the order dated 14/4/2026 by which zero FIR has been transferred from state of Assam to the state of Telangana without any prior intimation to the petitioner. Peruse the petition and the documents placed on record. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by step upon respondent number 3, 4, 5, and 6 be taken by state post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 and 2. Since Mr. Bordhakur entered appearance and received notice, however, extra copy of the petition be furnished to him during the course of the day. The learned counsel for the petitioner has pointed it out that the occurrence took place in Assam within the jurisdiction of this court. And the petitioner herein has paid the fee amount in Assam, and as such, this court, and as such, the jurisdiction of this case is of Assam. However, by impugn order dated 15/5/2026, the inquiry officer has transferred the case along with zero FIR to the jurisdiction of Goripalli PS of Hyderabad, Telangana. And under such circumstances, he has contended to stay the order dated 15/5/2026. Considering the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, it is provided that till returnable date, the impugn order dated 15/5/2026 stands state list after 4 weeks.
May it please your lordship. My humble submission is that an application under Article 226 of the Constitution of India or Section 528 BNSS for issuance and order for urgent basis. Urgent application for direction to preserve and produce CCTV footage, your lordship, involving imminent threat of life and liberty. Lordship.
Mr. Singh, have you gone through the petition
My lord.
and the pair made in this petition?
Yes, my lord. We have made 3 prayers, my lord. The prayers made in paragraph 2 and 3 are the repetition of the main prayer, my lord. The main prayer is that to preserve the video clippings of the incident which was captured there and to deposit it in the registry of the High Court, my lord, by the respondents. Respondent number 3 and 4.
So it was a mob lynching incident. 20 mobs are attacking on me, dated 1/8/2026 in premises of jail, Central Jail Lokhara, Your Honor, and under section 7 of the RTI Act of Life and Liberty, and Supreme Court directs to Parambir Singh, Saini vs. Balajit Singh regarding mandatory CCTV retention requiring immediate judicial intervention before the evidence is permanently wiped out. So I called many times police to preserve this CCTV footage on this dated, but directly denied. Central Jail Authority directly denied.
So you are pressing only one pair for preservation of the CCTV footage.
Yes.
Yes, Mr. Singh, any objection in passing any order here
We have to get
for
the-
preservation of the
we
CCTV
have to
footage?
get the instruction as to. We have to get the instructions for in this regard. That the incident has been captured in video. But as of now, we are not in a position to make any submission on that matter. We have to get the
Okay, we'll
Sir,
take it
we'll
up at
have
2 o'clock. In the meantime, you obtain instruction.
Can it be on Monday, my lord?
Sir, already 7 days left, and they raise all evidence if not ordered today. Your lordship kindly allow.
At 2 o'clock, you obtain verbal instruction.
My lord.
May I oblige?
2 o'clock today.
Huh? May I oblige?
May I please your lordship? Lordship, the learned counsel is on the writing code number 25 in item number 20. So a short passport is requested.
Time being.
Yes, right.
Okay.
Item number 43 for orders.
May I please, your lordship.
Mm.
Lordship, on the last occasion, there was a point on maintainability that was raised by the respondents.
Mm.
But in this matter, I am being led by senior counsel Leonardo Das. He's
Mm.
kindly out of station. So lordship would kindly fix this matter after a week.
Lordship, that the amount, lordship was directed in 2026. So that amount already been paid to
To the petitioner.
Lordship. The amount of 7 lakhs has been paid to the petitioner. The
You have
rest is-
received the amount.
Yes, your lordship, we have received that amount.
Okay.
But regarding the point of maintainability, senior counsel is going to argue. They have placed a judgment on the last occasion. I've gone
Yes.
through the judgment.
Yes.
Lordship, so since senior counsel is out of station, he has, as instructed, I have been instructed to take
Okay, all right.
adjournment for a week.
Mr. Hendrik, so what is the status of the recovery proceeding?
That is status. Can say he's sick, he not come last Monday. From he was suffering from illness.
Okay. Okay. Mr. Sen, you have filed the affidavit? Okay.
Why we have disbursed the amount then after this is from the inspection from the police.
Hmm.
Prior to receiving the market that later, the respondent for it has already done that.
Okay. So today there is a pair for adjournment. We will list the matter after 1 week.
Yeah.
Mr. Bhuya, learned counsel. appearing on behalf of Mr. Das. D. Das, learned senior counsel and conducting counsel for the petitioner, submits that Mr. Das is out of station and as such, he prays for listing the matter after a week.
Lordship, can it be on 16th of?
After 17th, after 17th.
After 17th.
17th.
After 17th, Lordship.
After 17, correct? Mr. Henry, learned standing counsel for the respondent number
Lordship, revenue department.
for revenue department and Mr. Mohanto for respondent number 8.
Lord.
Mohanto, you are for respondent number 8.
I am for 4.
And Mr. Borua for
Wait a minute,
1, 2, and 3. And Mr. Sen for respondent number 9 present. List on 9 September.
That payment was made, Lordships, on 16/7.
Okay. Mr. Hendrik, learned counsel for the revenue department, apprised this court that pursuant to the order of this court dated 30/3/2026.
2026.
Okay, 3/6/2026. A sum of rupees 7,11,809 rupees is released in favor of the petitioner, and the learned counsel for the petitioner has acknowledged the same.
Yes. Much obliged.
I got 44. The delay of 1 day, madam, for filing the reason.
Again, delay.
1 day delay, madam.
Mr. Loskor, any objection? No objection. Heard Mr. Konikor, learned counsel for the applicant, and Mr. Loskor for the state respondent number 1. This interlocutory application under Section 5 of the Limitation Act is preferred by applicant for condonation of delay of 1 day in preferring connected criminal revision petition. Criminal revision petition against the impugned order dated 22nd of April 2026, passed by the learned session judge cum special judge POCSO Sirang at Kazolgaon in special POCSO case number 40 of 2026. Mr. Konikor, learned counsel for the applicant, submits that there is only 1 day delay in filing of the criminal revision petition against the impugned order dated 22nd of April 2026. He also submits that the revision petition could not be filed in time. What is the ground?
Being my illiterate person, illiterate person.
Is it a ground?
Illiterate and financial condition.
That due to illiteracy and also due to financial constraint, the applicant could not file the connected revision petition in time, and the delay is not intentional, and therefore he has contended to allow this application. Mr. Lockor, learned additional PP for the respondent number 1, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so put forwarded for delay of 1 day in preparing the connected revision petition, and having found the explanation so put forwarded sufficient, this court is inclined to allow this petition. The delay of 1 day in filing the connected revision petition stands condoned. In view of the order passed in this IA, now the registry will register the revision petition, criminal revision petition, and list the same before the court as soon as practicable.
Deep loaded.
May it please your lordship. Lordship, I'm the legal aid counsel in this matter and I've been appointed with this case to prefer an appeal before this honorable court, Your Honor. And while I was awaiting to receive the documents and evidence that were adduced during the trial, there has been an inordinate delay of 31 days, Your Honor.
Hard miss.
Lordship, Valentina Villabino Tami.
Learned counsel for the applicant, Mr. Borthakur for the respondent. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 31 days in preferring connected criminal appeal against the judgment and order dated 29/4/2026 passed by the learned additional session judge Dibrugarh in session case number 288 of 2024. Convicting the applicant herein under section 326 and 307 of the IPC. The learned counsel for the applicant submits that. What is the ground?
Lordship, I was awaiting to receive the documents and evidence that were adduced during the trial to make an effective memorandum of appeal.
That the applicant was waiting to receive the documents from the learned court below. And the same have been received late. And on such count the applicant on such count the appeal could not be filed in time. And the delay is not intentional, rather it is circumstantial, and she has arguable point to be heard in the merit of the appeal. No, arguable points in the appeal, and the same has to be considered during the time of hearing, and therefore she is contented to allow this application. Mr. Loskor, any objection?
Sir.
Loskor, any objection? No objection. Mr. Loskor, learned additional PP submits that he has no objection in the event of condoning the delay of 31 days. But having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the explanation so put forwarded in this application. It appears that the delay of 31 days in filing the connected criminal appeal is then sufficiently explained, and accordingly the delay is then condoned. And in terms of above this, IA is then disposed of. In view of the order passed in this IA, now the registry will register the appeal and list the same before the court as soon as practicable.
Deeply obliged, Your Honor.
54.
Lordship, the applicant is already on interim bail, Lordship, on medical ground, Lordship. Lordship, may peruse the last order at page 36, Lordship. We have been, the interim period of interim bail was extended for 8 weeks, and the applicant was directed to appear before the learned trial court, Lordship. But due to
No, this application is filed
for extension of interim bail for another 8 weeks, and along with a prayer for allowing the applicant to appear before the medical board at Jawaharlal Nehru Institute of Medical Sciences in Lordship. As per the last order, Lordship, she was directed to appear before the medical board at Gauhati Medical College, but her critical condition is as such she cannot travel to Gauhati, Lordship. So she is under treatment in Jawaharlal Nehru Institute of Medical Sciences, which is also a government establishment, Lordship.
Where it is situated?
Imphal, Lordship. And applicant is a resident of Imphal, Lordship, Manipur.
Okay, let her senior come.
Lordship.
Variance, item 25.
Oh, this IA,
Lordship, F2.
okay.
25.
20.
Exactly at 2 p.m.
I remember.
28.
Legally, counsel was to close.
But where is the counsel for the accused?
CD was called for lordship. We have not received the CD lordship.
None appears for the accused on call. However, Mr. Locker, learned additional PP, and Dr. Pooja Agoral, learned legal aid counsel for the respondent number 2 present. Mr. Locker submits that he has not received the case diary and begs for granting him some time to produce the same. Pair allowed. List the matter on
19.
19. In the event of subsequent non-representation of the accused, appropriate order shall follow.
For time being, Your Worship.
Thirty-one.
None appears for the accused on call. However, Mr. Locker, learned additional PP present. Scan copy of the record received?
Not listening.
Not received. Office note dated 5/8/2026 indicates that scan copy of the trial court record has not yet been received. Restrict shall issue urgent reminder to the learned trial court for transmitting the scan copy of the record. In the event of list the matter after 1 week. In the event of subsequent non-representation of the accused, appropriate order shall follow.
32.
My lord, 483 bail application, my lord. The petitioner is behind the bar for 62 days. His period is already over, my lord.
This is 60 days offense.
My lord, up to 7 years.
Therefore, the inform and mother, I'll try Wakalat about today if we come into the party of.
No, we did 60 days.
62 days.
So Borthakur search sheet has not been submitted.
No, CD.
So he is entitled to default bail.
Yes,
Already, my lord, the main accused are already enlarged on bail by the honorable.
Thakuria learned counsel for the accused. Mr. Borthakur learned additional PP for the state respondent. Mr. D. Gogoi learned. You are amicus or engaged? Mr. Gogoi for the respondent number 2. This application under section 483 of the BNSS 2023 is prepared by accused June Dev Chaudhary, who has been languishing in jail as in connection with Biatas Early PS case number 121 of 2026 under section 351(3) stroke 75(2) of BNS, read with section 66E stroke 767B of IT Act, read with section 10 of the POCSO Act. Ms. Thakuria, learned counsel for the accused, submits that the accused was arrested on
It's on 6/7/2026.
7/6/2026, and since
Sorry,
then
madam.
he has
So
been
sorry, sorry, Your Honor. 7/6. It should be.
and since then he has been languishing in jail for last 62 days. Ms. Thakuria further submits that the statutory period of detention in this case is 60 days. Until then, no search sheet has been submitted by the investigating officer, and as such, the accused is entitled to default bail. So Borthakur learned additional PP also submits that the CD is with him and the search sheet has not yet been submitted by the IO. In that view of the matter, this court is of the view that the accused is entitled to default bail, and accordingly it is provided that on furnishing a bond of rupees 25,000 with one surety of like amount to the satisfaction of the learned special
Learned,
judge.
My lord,
Pakto.
SDJM, my lord,
SDJM or special judge Pakso. Rongia.
Rongia.
Rongia. The accused be enlarged on bail.
আমাদের কিন্তু অর্ডার তো এনেকে দিয়া আছে সাব ডিভিশনাল জুডিশিয়াল ম্যাজিস্ট্রেট দিয়া আছে may please your lord earlier my lord in earlier order my lord
Maybe.
learned subdivisional judicial magistrate Kamrup
No, no, you confirm where the case is pending. You appraise this.
Presently, my lord, it is not listed before my lord the session court, my lord.
No, it is POXO matter.
POXO matter, yes, my lord.
POXO matter has to be dealt with only by the
Special judge.
special judge.
Yes, sir.
So case record should always be there with the POXO judge,
Yes.
not with the subdivisional judicial
Yes,
magistrate.
my special judge come to.
Special judge come to. Obliged, sir.
33.
May I please allow? My lord, it's a charge-sheeted case, my lord.
That is completed. It's not number 2 is appearing.
He is appearing.
Yes, Lordship. So he needs some time.
Okay.
Copy has not been received by the Lordship.
Scan copy received.
We have received. But the
Okay.
counsel for the informant has not received.
Heard Mr. Bora, learned counsel for the petitioner, and Ms. S.S. Bora, learned additional PP for the state respondent number 1 and Mr. R. Mandal, learned counsel for the respondent number 2. The learned counsel for the respondent number 2 submits that the matter may be taken up on. When can it be taken up?
Next week.
Okay.
On 18 next.
Sorted. 14.
Timing 53.
May it please allow. Let the petitioner herein as an accused, number 17 in special case 7 of 26 months. But one of the bail condition was to deposit his passport, my lord. But the petitioner is a businessman by profession, my lord. And my lord, kindly see at page 6. He has been attending because he has a bitumen business, my lord, that's related to oil, my lord. And there are conferences that he had attended. In page 6, if your lordship have a look at the petition. But in Dubai, my lord, Bangkok, my lord, this time it was scheduled on 27/7 at Oman, my lord. And my lord, one other conference at China. What happened, my lord? We file an application before the special judge, CBI, my lord, on 18/7. My lord, to kindly have a look at page 91 is the China conference, my lord.
So your passport has been seized.
Not seized. My lord, it is one of the conditions of the bail, my lord, to deposit the passport while grant, my lord.
So, my lord, we have filed an application before the special judge, my lord, for temporary release of the passport, my lord, for travel abroad. Now, my lord, that application was filed on 18/7, my lord.
What is the impugned order?
My lord, in fact, the order is that the matter has been fixed on the next date, my lord, that your lordships find at page 104, my lord. Last page.
Yes.
The case is put up so file by so the copy. Permit they will file the reply and the date as filed. But our contention was not since
When the date is fixed?
not on 10th, my lord.
10th of this month.
Yes, my lord, one of my prayer has already become infructuous because 27th is over. My lord, the next date is 1st and 3rd September. My lord, some time is also required for obtaining visa, my lord. My lord, at this stage, I am praying, my lord, let the special judge consider it, my lord, on 10th, my lord, without there even further.
Where the date is fixed?
My lord, on 10th. Next date is 10th, my lord.
Where it is fixed?
But earlier, the matter has been fixed on 10th. We moved on an off date, my lord, stating that, my lord, it should be expeditiously decided. What the learned special judge has done, my lord, it has fixed on 10th. But though in this order, my lord, it is not reflected, my lord. The case
Then
is
how can this court comes to know that 10th is the fixed date by the trial court?
I took that. My lord, at 2, my lord, I'll provide the certified copy of the other orders that I have placed on record, my lord.
And further, you have filed this petition under 227. Yes, your alternative remedy is there in the trial court also.
No, my lord.
So when the alternative remedy is available, this petition is not maintainable.
227, my lord, because of supervisory jurisdiction.
Maybe.
Our contention is, my lord,
how the supervisory jurisdiction is to be exercised by this court is well settled. When alternative remedy is available before any other court.
No, my lord, we don't have any other alternative because this
trial court has not rejected your pair.
Lord, I am not regarding rejection, Lord. Since my one of the conference was on 27 July, Lord, Lord, the passing of order.
Why don't you file one application there to prepone the date of hearing?
Lord, that is the application we have filed, Lord. The special judge has fixed it on 10th, Lord, on Monday.
No. Now you can file an application to prepone the hearing.
Lord, at this stage, Lord, my prayer is, Lord, let the special judge consider it in 10th. There should not be further, Lord, only thing. Because one, Lord, already we had filed.
To issue such direction on merit.
No, I'm not on merit.
No.
My only prayer is, Lord, let him consider this. There should not be further.
You have to satisfy this court that this petition is maintainable.
Well, I'll satisfy your lordship. My lord may take it at 2, my lord. I'll also place that order.
May I please your lordship? I would like to apprise your lordship. This petition is filed under, this is a criminal revision petition, filed under say, Article 227. There is no impugned order. And admittedly, paragraph number 13 and 15 will speak that one application is pending before the trial court.
No, therefore,
consideration of special.
Even if they will bring the order, it is not maintainable at this stage, your lordship.
I am not challenging, but the fact that the matter, I'll satisfy your lordship at 2 o'clock.
Order is reflected 10/8, it is pending.
Okay, at 2 p.m.
My lord.
My lord, in this case, my lord, parties have compromised the matter, my lord. Although it's a POCSO case, my lord, but the boy is also, my lord, a young boy, and my lord, the victim is also young. So they compromise the matter, and the parents actually they want to get their children married, my lord. And my lord, he has also appeared for the informant side, my lord. Both are young, my lord. He's already arrested, my lord, on 26/6/2026, my lord.
File. Under section?
Lordship, only receipt number has been given. It here lordship, the case is registered under section 6 of PROCEEDINGS.
What is the age of the victim, girl?
My lord, victim 16, my lord. as
16
per FIR.
lordship.
And
Learned counsel for the respondent number 2. This application under section 483 of the BNSS 2023 is preferred by the accused, who has been languishing in jail in connection with Buragaon PS case number 52 of 2026, registered under section 137, which make it 2/64 of the BNS 2023, read with section 6 of the POCSO Act. The learned counsel for the accused submits that the parents of the accused and the victim have settled the dispute and also decided to solemnize marriage between the accused and the victim. And as such, he has contended to allow the accused to go on bail. However, the learned additional PP apprised this court that after completion of investigation, the IO has already laid charge sheet against the present accused, being charge sheet number
Vice case number 58/2026, dated 30/07/2026.
In that view of the matter, this court is inclined to dispose of this petition by directing the petitioner to file an application before the learned trial court for grant of regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. None appears for the accused on call. However, Mr. B. Sharma, learned additional PP present. Mr. Sharma apprised this court that he has received the case diary. Service report received.
Not received.
But he has not received the service report. Accordingly, it is provided that RSSL lists the matter on that day. Mr. Sharma shall produce the service report before this court.
27.
And in the event of subsequent non-representation of the accused, appropriate orders shall also follow.
37.
May I please, sir? Petition beyond the bear as on the 33 days lordship. Here is the only allegation in this that on 6/7/2026, one vehicle was found near the police station, and inside the 19 number of Patel was found, lordship. Thereafter, only allegation present petition that the present petitioners will appear approach the police station and to try to manage by offering cash amount. The section is which is at register lordship. This is not attack against the petition present petitioner lordship. And thereafter the one Zakir Ali lordship
Okay,
is the
whether the not received. Let the city come.
lordship. This is Sarsit submitted lordship. I have obtained Sarsit.
Sarset submitted.
Lordship,
Then you go and apply before the trial court.
kindly hear the matter lordship. One of the Zakir lordship, Zakir Ali, he is the owner of the.
No, you go and file an application there before the trial court.
Then kindly call for the scan copy of the cash diary lordship and record lordship. Because the case will committed thereafter we get a bail lordship. Otherwise there is a long.
Okay.
Already
Heard Mr.
Ketel
P.
also
Islam,
demand.
learned counsel for the accused, and Mr. P. Sharma, learned additional PP for the state response.
Sarsit number.
The B. Sharma submits that he has not received the case diary. But Mr. Islam, learned counsel for the petitioner, submits that after completion of investigation, the IO has submitted charge sheet, being charge sheet number
307/2026,
dated
dated 29/7/2026, and registered under section 303.
provided that RSSL call for the scan copy of the TCR from the learned court below.
This is
List the matter on.
kindly short date maybe this is a Hazo PS lordship. The section which is registered not applicable in this case.
But charge sheet has been submitted against you.
Against present petition, but Jimma already given.
Different thing.
The Jimma, the present petitioner is one of the seller of the in the case.
Okay,
lordship.
let the record come, we will see.
Short date my kindly lordship.
Short date before
13 lordship,
15.
13 or 14. हाँ चल रहा
Okay.
Oh, they still okay.
Pending against. Number 54.
I will appear in this case, Lordship.
Do you have Ukalat Nama here?
Lordship, no, Lordship.
No. You ask him to remain present. In the first half, when you have mentioned the matter, I have specifically directed you. After something.
30. I get to mention item 33.
Item
33.
30?
33. A direction may be given to target bail application copy to respondent number 2. Already called.
May present.
Taken up after some time when creation of put number 1. Other fixed that period, item 51.
May it please your lordship.
Yes.
Lordship, it's a regular bail application, your lordship. In this case, apart from the merit of the case, your lordship, I am challenging that the IO has not complied with the provisions of section 35(3) of the BNSS. This is
Okay, Mr. Borthakur, you have
Yes.
gone through the.
Yes, sir. I have done it before. Earlier, your lordship, my lord, in bail application number 26 from your lordship has allowed one of the, not in this case, but in other cases. But why this case is my lord, some not saying, my lord, here, my lord, in some detail notice here, there, my lord, I would like to point out, my lord, first the note, my lord, which is there in the forward report, my lord. Case 24, my lord.
No. Whether in the case of Satinder until
Yes, my lord. Yes.
it speak about the note.
Yes, my lord. Regarding that, my lord, it is not that there is nothing in the report that, my lord, why notice 35(3) not served to the present petitioner. It is not that total non-compliance, my lord. It is, my lord, in fact, my lord, there is a note why 35(3) was not served. Specifically, in my lord, he has stated some reasons, my lord, on the basis of the, my lord, contents of the FIR and the materials collected during investigation. For a moment, your lordship, due to the nature of the offense, there was a high likelihood that the accused persons might, because these are, my lord, all by the evidence in the form of electronic evidence. If for a within a second, my lord, that can be deleted by an accused person, my lord. Likelihood that the accused persons might have come and crucial electronic evidence. If served with notice under section 35 PROCEEDINGS prior to apprehension. Further, the accused persons were found, the accused person is involved in committing found deeply engaged in the commission of a committal offense for necessitating immediate apprehension to prevent continuation of the illegal activity. Serving notice at this stage would have hampered effective investigation and enforcement action. Hence, the interest of a fair and effective investigation. Notice under section 35(3) BNSS could not be served at the time. So, my lord, regarding that, my lord, 35(3), why, my lord, it is, my lord, not served, my lord, he has specifically mentioned regarding, my lord, considering that aspect of the electronic evidence, my lord, suppose, my lord, accused person served.
No, that's all right. My question is very clear. That whether by giving the note in the forwarding report, the requirement in the case of Satinder until is fulfilled.
My lord, may I be wrong, but from my side, my lord, only after going down, that my lord, compliance of second, my lord, Arnesh Kumar was followed, that complied, my lord. Why, my lord, I would like to, your lordship, my lord, may kindly, for a moment, your lordship, is the order, my lord, although in this case, your lordship has allowed on the ground of not compliance. Order also, my lord,
Lordship,
your lordship may kindly,
in this matter, there's a matter pertains to 24-25, your lordship. And whether the note is disclose any objective satisfaction, your lordship.
your lordship may kindly. My lord, that is my lord, paragraph 9.1, my lord, that is from the judgment of the pocket, my lord, from the judgment, I would like to point out. From a plain reading of the aforesaid provisions, it is evident that a person accused of an offense with imprisonment for a term which may be less than 7 years, extend to 7 years without cannot be arrested by the police. Only on his infection that such person has committed the offense punishable as aforesaid. A police officer before arresting such cases has to be further satisfied that such arrest is necessary to prevent such person from committing any further offense or for proper investigation and defense or to prevent. So these are the my lord, at 7.2, my lord, the law mandates the police officer to state the facts, my lord. Those facts are there and record the reasons. Reasons are also in writing. So, my lord, reasons in writing, my lord, that is there, my lord, which lead him to come to a conclusion covered by any of the provisions aforesaid while making such arrest. The law further requires the police officer to record the reasons in writing for not making, in case of not arresting the accused, also, my lord, accused has to, my lord, write the reasons. But here, my lord, why, my lord, the person was arrested, my lord, and why it is not served, my lord, that is given the note of the right, that is in the form of writing, my lord.
Lordship, in this matter, no other complaint or FIR is registered against this person apart from this FIR by the SI, your lordship. On what basis and what is the objective satisfaction that has led him to the arrest has not been reflected, your lordship.
Okay, except this technical reason, what is the merit of the case? What is your submission on merit of the case?
And lordship, moreover, your lordship, the allegation in the FIR, lordship, will kindly come to page number 17. It's under section 318, 316 and 61(2) of BNS, read with section 66D of the IT Act. So, lordship, section 81 of the Information Technology Act states that this Information Technology Act has an overriding effect over the general over the other general laws, your lordship. So, as there is no other FIR or complaint registered against this person, and moreover, when this the matter pertains to electronic platform, it is covered by the Information Technology Act. So, section 316, 318, and 61(2) of BNS may not attract, your lordship. Moreover, this section 66D is bailable, your lordship. I am placing judgment also, your lordship.
No. If from the perusal of the section itself, it appears that the offense is bailable, why judgment is necessary?
It is reiterated by the apex court also, your lordship, that when offenses are covered by the Information Technology Act, it comes out of the net of the IPC.
And my lord, stated that the accused is a student. Being a student, my lord, he is running a, my lord, an online platform that is winner. That is a science. He stated that
it is not illegal in India, not illegal, your lordship.
Converted, my lord, those, my lord, US dollars to Indian rupee, my lord. Where is the person? How he can, my lord, convert, being a student, how he can convert such a huge amount of 45 lakhs rupees, my lord. And where is the, my lord, permission? Where is his, my lord, authority? That he can, my lord, convert the huge amount that he is authorized to, my lord, convert those US dollars in that particular platform, my lord, in the online mode, my lord. Huge amount, my lord. Being a student, my lord. And my lord, in the, my lord,
Operating an account in the
considering the nature of, my lord, gravity of these cyber offences, recently, my lord, one, although, my lord, that is not, Supreme Court also, my lord, recently, my lord, observed that those, my lord, regarding those cyber house areas, those, my lord, cyber offences, my lord. And here, my lord, how these, my lord, the victimized persons, my lord, even those victimized persons, not from the, they also, my lord, not only from a particular state, they are, my lord, from, my lord, all over the country, and some, my lord, cross border, my lord, also, my lord, those, my lord, funds, they have, my lord, while they, some victimized persons also, my lord, those amounts were, my lord, deposited in their account, how do the electronic?
Okay, we'll say. We'll pass the order.
Yes, sir.
Madam, you hand over the judgment to the court master.
oblige, your lordship.
Item number 55 for hearing. One case will be before the Supreme Court regarding victims of related cases. Although that case was not, till now there is no final order yet passed, but regarding some, in that case also considering the such type of offences, one order passed on, considering the case regarding the digital arrest, although, my lord, considering that otherwise cyber related offense, I am handing over one.
Okay, we'll see.
55.
Mr. Borthakur is there.
Yes, sir. I have received the report from the authority.
How is the condition? Not good.
Good.
Good. So, madam, now he is leading a healthy life. He is of sound mind and good health and doing his basic day-to-day works. So, this IA will be considered along with the criminal appeal. We'll finally hear and dispose of both the matter. Take down. Heard Miss as Z Hayat, learned counsel for the appellant, no, applicant, and also heard Mr. Borthakur, learned additional PP for the state respondent. Person to order dated 6/8/2026, Mr. Borthakur has produced on a report regarding the status of health of the applicant from the superintendent of jail. No, from the senior medical and health officer, jail visiting doctor of district jail depot. And perusal of the report indicates that the applicant is in sound mind and good health and doing his day-to-day works. In view of above, this court is inclined to dispose of this petition application along with criminal appeal number 75 of 2026. SSL lists the criminal appeal number so and so along with the IA number so and so on 10th of September for final disposal.
May I please, your lordship, the Shall we have to proceed for the paper book? Paper book, Your Lordship?
Paper book record is available,
Yes.
not necessary. You can go through the record.
Correct. Obliged.
Coming item 52.
It's out of orders, it's long matter. The plan and estimate for activity servicing and all was sent by the to the IT prison. The year on 11th October 2025, madam, and pursuant thereto, in terms of the work order of 9th March 2026, the repairing and extension and replacement of the work has started from April 2026 only, and it will take another a lot more time, madam. Therefore, due to this reason and above all, due to the hard drive issue and the renewal of the server license also, it could not be possible. Therefore, there is no footage on that. So now the CCTV system is not working there. Repair and extension and replacement work is still going on, my lord.
Sir, Your Lordship, মই অসমীয়াত ক'ব পাৰোঁ নে?
Yes.
Sir, এইটো সিহঁতে প্লেন কৰিয়ে কৰিছে যাতে গোটেই ইনচিডেণ্টটো যেতিয়া সেইদিনাখন হৈছিলে 1 আগষ্ট স্যাৰ 20 পিপলছ মানে ড্ৰাগছ এডিক্টেড তেওঁলোকে মোক জানি বুজি সিহঁতে লগাই দিছে মোক এটেক কৰিবলৈ স্যাৰ ৰড ইটা আদি এটেক কৰিছে মই 20 মিনিট সাৰ্ভাইভ কৰি আছো মই পুলিচক ফোন কৰাৰ পিছত বশিষ্ঠ থানা আহি মোক
8 of the BNSS 2023. The petitioner has tried for issuing direction to the respondent number 3 and 4 to immediately seize, seal, and preserve the raw, unedited CCTV footage along with the system log, stroke DVR data from the cameras located at Central Jail recorded between 2 p.m. to 4:30 p.m. on 1st of August 2026 and to deposit the same before the registry of this court, and also to direct the respondent number 4 or an independent investigating team to forthwith seize, seizure and preserve the original DVR stroke hard disks and CCTV footage recorded at Bosisto PS between 2 p.m. and 4:30 p.m. along with certificate under section 63 of the BNS 2023. No, BSA 2023. And also to direct the respondents to produce the CCTV footage before this court. No, in which part of this order,
My lord.
your petition has been mentioned?
My lord has read the order dated 18/7 at last page.
No, 10/7/26.
Yes. No, 10/7/26 is the last order by which the matter has been fixed on 10/8/2026. My lord, I have filed an application on 18/7, my lord, on an off date requesting the court to expeditiously hear my application. Indicating therein, my lord, that I propose to visit Oman, where the conference is scheduled on 27th, and China on 1st and 3rd of September. The learned special judge, my lord, has passed the order, fixed this case for filing objection by CBI, not even mentioning that it would be heard, my lord. Thereby, my lord, making my prayer qua my visit to Oman infructuous. And second, my lord, because some time would be required for processing of visa. My lord, I am not saying that direction may be passed for, my lord, to decide, allow. My lord, what I am submitting is by a flux of time, my lord, my applications get infructuous. My lord, your lordships under 227, my lord, exercises power of jurisdiction, supervisory jurisdiction, and this include a direction to be issued to the trial court, my lord, in exceptional cases, my lord, to decide certain issues in time-bound frame, my lord. In fact, the apex court in the constitution where judgment 2024 6 SSC 627, my lord, amongst others, my lord, this has one of the issue was, my lord, whether the stay gets vacated automatic. There, sir, many issues were discussed. Among them, my lord, it was also an issue whether under supervisory jurisdiction, High Court's power should be curtailed. what the apex court has said, my lord, in ordinary courts, my lord, the supervisory jurisdiction, by invoking supervisory jurisdiction, the time frame should not be fixed, but the power should not be curtailed, because in exceptional circumstances, my lord, this power can be exercised. So my only limited prayer is, my lord, since
No, there are several decisions of Supreme Court
my lord,
that when alternative remedy is
with due
available,
respect, my lord,
this
in this,
jurisdiction.
yes, yes,
cannot
my lord,
be-
I understand.
Uh,
My lord,
then-
in those cases, my lord,
Mm,
where there is a provision for appeal, one cannot go under 227
mm.
or writ jurisdiction. But in this case, my lord,
Here,
there is-
your application is pending there.
it's pending. What I am praying for is for an early disposal of my case. So in that regard, my lord, there is no other remedy as regard appeal revision except 227. I am calling upon your lordships only for a direction that to direct the trial court, my lord, to expeditiously dispose my petition that is fixed on 10th, because by efflux of time, one prayer has already become infructuous, and by the time it decides and I cannot approach, my lord.
Trial court is the appropriate court to deal with the same.
Yes, yes. So your lordship has
In,
power under 227.
No, no,
My
no,
lord
no.
will exercise that power or not. It
No, no.
depends upon your lordship's
Only
discretion.
in extraordinary circumstances this court can consider that too
But
while alternative remedy is not available.
my lord, it's not a case of alternative remedy. My lord, there is no other remedy, my lord.
Mm.
My lord, if tomorrow,
So your application has not yet been dismissed or disposed of.
my lord, my case is, since the application, my lord, two aspects, my lord. First, I filed on 18/7, my lord. The trial court would have, my lord, taken up expeditiously. That has not been done. Now fixing on one, my lord, date has already gone. The second date is 10th. But I am praying for your lordship that has only been fixed for filing of objection, my lord. But I am praying that your lordship may direct to decide that expeditiously. That much, nothing more.
That cannot be.
But because what has happened is, my lord has seen.
Under 227, that can.
But that power your lordship has under
No, no,
supervisory
no, sorry.
review. Whether your lordship would exercise or not, that is not, my lord, that is upon
sorry.
your lordship.
Sorry.
My lord, you just have a look at para 43.
No, in that case, 227 has not been dealt with.
It has been dealt with 227 supervisory jurisdiction, my lord. The apex court has said.
No.
My lord, will just, if your lordship permit, constitutional courts in the ordinary course should refrain from fixing a time-bound schedule for disposal of cases pending before any other court. Constitutional courts may issue direction for the time-bound disposal of only in exceptional circumstances.
Regarding maintainability of the petition under 227.
But otherwise, I have no other remedy. I can only seek before your lordship under 227. If your lordship says that 227 is not maintainable, my lord, I have no other remedy, because what I am praying for.
No other remedy means your petition is pending there.
Yes.
It has not been disposed of.
My lord, even delaying my petition, I have a right, my lord. And that's why I have come before your lordship.
You go and apply there. Yes, what is your submission?
But I have already applied. That application is pending.
But it is not maintainable because matter is sub judice, issue is sub judice. It is pending there. So as of now, it is not maintainable unless and until that is decided. And that too in the form of 227 and criminal revision petition.
Okay, we'll pass the order. Okay. Next item.
Pending item 25.
Well, in that case, my lord, if you.
Pardon?
Well, the matter is fixed on Monday, my lord.
Yes, today we'll pass the order.
My lord.
Pending 25. In this case, the issue for your lordship is that the arrest will be carried.
No, Mr. Kayal, morning while she has mentioned the matter, I have asked her to ask you to remain present at 2 p.m. today. At 2 p.m. while we have taken the matter, again the same submission that you were in next in another court. Pardon?
I was asked by court number 10 to remain present at 2 o'clock to assist the court in GST matter. That's why I was on less at that time.
So prior to that, you were directed to remain present here.
Actually, today I was in court number 1.
I will not take up your matter. Leave this matter before another bench to the.
Pending 54.
My lord, I have a limited period also.
Yes.
Lordship, the last order is at page 36, Lordship. The interim, page 36, Lordship. Interim bail of the petitioner was extended till 8 weeks, Lordship, and there is a rider, Lordship, if she fails to, and with a direction to appear before the trial court within 8 weeks, Lordship. Because of the prevailing medical condition of the accused applicant, Lordship, he is not able to even come to the Gauhati, Lordship, as advised by his doctor in
Where is the
Chennai.
medical document?
Medical document, Lordship, the earlier medical documents are there from at page 27, 26, and the latest medical document is page 37, Lordship. She is under regular treatment in JNIMS, Lordship. Again, the race
No,
for
no,
another
what is the ailment?
ailment, Lordship. Now she has, as I am told, Lordship, as although it is not written here, she has developed convulsion, Lordship, which is a rare neurological disease, Lordship.
No, whether convulsion is so serious that she cannot appear before the court here.
Lordship, I have personally talked with her via video conferencing, Lordship. She is visiting this particular hospital at Manipur with the help of two individuals, Lordship. She can not even walk properly, Lordship. So what I'm proposing, what I'm praying for, Lordship, the interim bail prayer may be extended for another 8 weeks. We have prayed, and by that time, Lordship, she is ready to appear before the medical board at Jawaharlal Nehru Institute of Medical Sciences, which is also a government institution, Lordship, at Manipur, Lordship. She underwent a surgery. Thereafter, her condition got deteriorated, Lordship. Initially, surgery was done, Lordship. This is a medical document of 27 July, Lordship, page 37, Lordship. We are ready to
So
appear
you say on 9/6/2026, there is one order
Lordship.
that if you fail to appear before the medical board,
Lordship.
then you will be compelled to subject herself to medical board of Gauhati Medical College and
Lordship,
Hospital.
I fully agreed, Lordship, but see, that's why we are praying, Lordship, with all respect, that she will appear before the medical board at JNIMS, Lordship, which is also a government institution, Lordship. She is taking regular.
No, direction was to appear
Yes,
before
Lordship,
the
but,
medical board at Gauhati Medical College.
But because of her medical condition, she is not able to.
No, these prescriptions are not sufficient to show that you are suffering from convulsion.
Lordship,
Where it is mentioned?
Lordship, I have been told by.
No, your verbal instruction will not do.
Lordship,
Whether this
Please proceed, page 37. There is a hand not
advice for rest for another 2 weeks, Lordship.
for 2 weeks.
But she is not in a condition to travel down to Gauhati, Lordship, as I am told,
This
Lordship.
is nothing but a prescription only. This is not a medical report also. This honorable court, Lordship, clearly, Lordship is to see.
Lordship,
Many times, Lordship, after getting the bill, Lordship, she is not complying with the orders. Every time the file application for extension of time.
Lordship, because of her medical condition only, Lordship, we are compelled to file application repeatedly. Lordship,
where is the medical document?
Lordship, regarding convulsion, Lordship, I will seek instruction whether she.
No, sorry. Let us do one thing. We will extend it for 2 weeks.
Lordship.
Within that 2 weeks, you have to appear here.
Lordship, can it be in JNIMS Manipur, Lordship?
Not at Gauhati as per order of this court.
Lordship, she is not able to come to Gauhati.
Sorry.
She will not be able to, Lordship.
Maybe then you will be compelled.
Lordship, but her physical condition is not that so, Lordship, that she can appear and come down to Gauhati.
Mr. D does learned counsel for the applicant.
Can it be for some longer time, Lordship?
No.
Beyond 3 weeks, Lordship.
Already sufficient time has been granted to you.
I'm praying for 3
and
weeks.
you are buying the time.
No, Lordship, we are, with all respect, we are
And
not
also heard
avoiding
Mr.
the court's
Kyle
order.
learned standing counsel for the opposite party. In this interlocutory application, the petitioner, the applicant has applied for extension of the interim bail granted to the applicant by order dated 1/12/2025, passing BA number 2750/2025. And the subsequent order dated 15/12/2025, 9/1/2026, 27/2/2026, and 7/3/2026. And also the order dated 11/3/2026, 7/4/2026, 9/6/2026, passed in criminal, IA criminal number 258 of 2026, IA criminal number 284 of 2026, and IA criminal number 289 of 2026, in bail application number 2750 of 2025. On medical ground, Mr. Das Learned Counsel for the applicant submits that the applicant is suffering from convulsion, for which she is not in a position to appear before the medical board at Gauhati Medical College Hospital. And he further submits that the applicant may be directed to appear before the medical board at Gauhati at JN
Jawaharlal Nehru Institute of Medical Science.
Jawaharlal Nehru Institute of Medical Science, Parampat, Imphal, East Manipur. East Manipur, which is also a government hospital. Per contra, Mr. Kyle Learned, standing counsel for the respondent stroke opposite party, submits that the applicant has not been appearing before the medical board, and she has been taking
Medical board
repeated
for
adjournment.
But lots of may I interrupt, for appearing before medical board, there is only one order. What is the last order? Also? Earlier order, there was not such direction.
And therefore, Mr. Kyle has contended to dismiss the petition. But having heard the submission of learned counsel for both the parties, the court has carefully gone through the application, the documents, lesson record, and also perused the order dated 9/6/2026 in IA criminal number 589 of 2026. And also the medical document, which is enclosed with this application as Annexure E, Prop 11 at page number 37. And also the previous medical document at page number 26, 27, 26 and 27.
34 also. 31 to 30 to 31 and 34 also.
Thirty, 31, and 34.
Yes.
34. Having considered the submission of learned counsel for both the parties and also taking note of the medical documents, this court is inclined to direct the applicant to appear before the medical board of Gauhati Medical College Hospital. Cover 2 weeks.
Lordship, can it be 3 weeks, Lordship?
Sorry.
1 week more, Lordship.
No.
With all respect, Lordship.
No. 25th of August. Then in the event of failing to appear before the medical board as ordered in the order dated 9/6/2026, the applicant will be compelled to appear before the board. In terms of this, I stand disclosure.
I'm obvious.
Number 38.
May it please, sir. My lord, the petitioner before the allegation in nutshell is this, my lord. The petitioner before your lordship is a railway section engineer. Now, a complaint has been lodged by a man who works under a contractor alleging that I have demanded 20,000 rupees for clearing some bill. That is the allegation against me. Based on the allegation, my lord, the CBI has arrested me, and for last 55 days, he is in custody. 55 days he is in custody. Now, my lord, interestingly, my lord, just 1 month before the FIR, this very petitioner have filed a complaint against the informant, that the informant was pressurizing him for some illegal acts, and he has also threatened him. I'll take your lordship first to the FIR. My lord, may kindly come to page number 19.
Mr. Biswas, for how long you were behind the bar?
My lord, 55 days, my lord.
55 days. And what is the maximum period of
60,
punishment?
60.
60. You were behind the bar for
5 days.
55 days.
Next submit before your lordship.
Let him complete. Yes.
Because the charge sheet has been filed, that is why I would like to apprise your lordship. Charge sheet has already been filed, so they can avail this facility in going to the trial court. They can file this petition there itself. It is not maintainable here.
Maintainable?
How?
So because charge sheet has already been filed.
No, filing of charge sheet is a bar in a bar.
Lordship, no bar your lordship
Then
has.
why you were submitting that it is not maintainable?
Because all the total record is there.
Maybe.
The case.
Maybe.
The trial court will deal with.
We may call for the record also if
Yes,
necessary.
that can be done if the TCR can be called for them in that event.
But if it is 60 days offense,
Yes, sir.
he is already behind the bar and investigation is completed.
Investigation is completed.
Then
I have no issue.
the question of hampering investigation does not arise. Charge sheet has been submitted, he will face trial. So where is the bar in releasing him on bail?
I'm not on that mark.
Then?
My concern is that when charge sheet has been filed,
Hmm.
so at present, all the case record is there in the trial court.
All right.
So
He will appear before the court, trial court, and he will face trial.
it is up to the lordship to have ample power to pass an appropriate order to that effect.
Hmm. No, he was submitting that the petition is not maintainable. Why not maintainable? Where is the bar?
As such, there is no barrier. But the reason there's every time when the charge sheet has been filed, usually they.
That's all right. In some serious cases, we used to direct the petitioner to appear before the trial court. But this case is not so serious. What is the punishment for section 7?
Section 7 punishment, my lord.
3 years or more? 5
Shall be
years?
punished with imprisonment for 3 years,
3
which
years.
may extend to 7 years, 3 years and 7 years. Even notice under 35 in such an offense. And my lord, what I am praying is this, my lord. Right, wrong, my lord, we are not on trial. I have filed my petitioner have filed a complaint against this man who has, that is prior in point of time. He promised that he'll implicate me in some case. It is on record. I have given it. He said, I'll ensure that I take your job. My lord will kindly see page number, my complaint, page 19, which is prior in point of time, 19. This is Kuntal Chakraborty. I have complained against this Shumon Chando, that's the informant, 1 month before.
Let him face trial before the trial court.
I'm deeply obliged.
Heard Mr. বিশ্বাস, learned counsel for the accused. Ms. Kumari for the learned standing counsel for the CBI. This petition under section 483 of the BNSS 2023 is preferred by accused Kuntal Chakraborty, who has been languishing in jail hazard in connection with FIR number RC 0202 6A003 under section 7 of the PC Act 1988. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by one. FIR is at page number?
My lord, page number 13. Pankaj Kumar Chaudhary.
Pankaj Kumar Chaudhary on 13/6/2026. The allegation against the present accused is that he has demanded 1% of bail for the work of construction of biotoilet in Indian Railway Silchar under subcontract, where a bill of rupees 20 lakh was pending in Railway Silchar branch for the work done by one Suman Kumar Chandra. Mr. Biswas, learned counsel for the accused, submits that the accused is behind the bar for last 55 days and the investigating officer has already completed investigation and submitted charge sheet against the accused. And that before 1 month of lodging of the FIR, the accused has lodged one complaint to NF Railway COD/SCL NF Railway Silchar
Yes.
Silchar against Suman Chandra.
Yes. The same.
Against Suman Chandra of Udarband, Kasar, Assam. And that the accused is ready to face trial, and under such circumstances, he has contended to allow this application. Per contra, Ms. Kumari, learned standing counsel for the CBI, submits that after completion of investigation, the investigating officer has submitted charge sheet, and the record is available before the learned trial court. And as such, the accused may be relegated to apply for regular bail before the learned trial court. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record. It is not in dispute that the accused is languishing in jail hazard for last 55 days. And it is the categorical contention of Mr. Biswas that the statutory period of detention in this case is 60 days. And in the meantime, charge sheet has also been submitted and the applicant is ready to face trial. And in view of the given facts and circumstances, This court is of the view that further custodial detention of the accused in the interest of investigation seems to be not warranted. Accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned trial court.
Trial court.
Who is the trial court?
CBI court, this Chanmari, what is the name of
Special
it?
justice.
Special Judge CBI.
But the areas have to declare the court number. Special judge CBI court number.
No, Special Judge CBI, there they will assign the court numbers.
Special Judge CBI court number 1. Usually 1 used to take court number 1. Kamrup M. Gauhati.
But
In terms of above this, BA is that's a disposal.
I'm deeply aware. Let reserve. Huh? Here, regular bail application, the 3 persons, they were arrested. Lord, you kindly see the FIR, page 16.
Filed this petition on
That's it committed under section.
under section those are the sections, my lord.
Yes, madam, you have gone through the record.
you also go ahead flag mark the. Here also charge the copy of receipt is not there.
Charge sheet submitted on prepared on 16. I counted again. Then my lord, it was placed in the before tribunal on 6/7/2026. I filed this application on 18/6. Later, my lord. That is why I could not brought this charge sheet on records. Now, however, my lord,
Charge sheet is submitted under section.
I have not seen it, my lord. The core is there.
Then explain the petition. Not like code.
137 to 1/164(1) and 4. 4
Section 4. You go and apply for regular bail there since. charge sheet is
What
submitted.
happened in the meantime, my lord, actually,
Hmm.
actually there is a love affairs. Now,
No, go Sir Purkayastha learned counsel for the respondent number 2. This application under section 483 of the BNSS 2023 is preferred by accused Masuk Raza alias Masud Alam, who has been languishing in jail hazard in connection with Lahore.
no, it is not every, my lord. Anticipatory bail.
Anticipatory bail.
Anticipatory bail.
Anticipatory bail also.
He is not.
Oh, okay. Who has been apprehending arrest in connection with Lahore PS case number 06/2026 under section 137, which will make it 2/64, which will make it 1 BNS, read with section 4 of the POCSO Act. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by 1
Number 3.
1 Abdul Ali, within bracket, name withheld, actual name withheld.
My lord.
On 11/1/2026. The allegation against the accused, or no, against the applicant is that he has kidnapped the victim girl and taken her to a hotel at Moregaon, and there he has committed rape upon her. Mr. Ahmed, learned counsel for the accused, submits that the accused and the victim, the family members of the accused and the victim have effected a compromise and after the girl, after attaining age of majority by the victim girl, they will solemnize the marriage. And under such circumstances, he has contented to extend the privilege of pre-arrest to the present applicant. Ms. S.S. Bora, learned additional PP, however, vehemently opposed the petition on the ground that in the statement under section 183 of the BNSS 2023, the victim has clearly implicated the accused with the offense alleged in the FIR, and that nowhere in the statement she has stated that she has any affairs with the accused person. And under such circumstances, he has contented to dismiss the petition.
And she's a minor, also certificate.
Mr. Pukas.
Birth certificate is there to substantiate the fact that she's a minor.
Mr. Purkeso, learned additional,
Respondent 2.
learned counsel for the respondent number 2 also subscribed the submission of Mr. Ahmed, learned counsel for the accused. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the application and the documents placed on record, and also carefully gone through the scanned copy of the record received from the learned trial court. It appears that the IO has completed investigation and submitted charge sheet, being charge sheet number 67 of 2026 on 16/6/2026. And in view of the aforementioned facts and circumstances, this court is inclined to dispose of this petition by directing the applicant to approach the learned trial court by filing appropriate application. And on such application being filed, the learned trial court shall consider the same in accordance with law.
And also by considering the compromise at
No direction.
Hello.
May I please, Lordship?
Yes.
This is an application under section 482 BNSS, Lordship. And FIR is at page 13, Lordship.
Here we have the case along with the service report. Service completed.
Is it FOXO matter?
FOXO matter.
Okay. Heard Miss Didas,
MS Didas, Lordship.
learned counsel for the applicant. Mr. B. Sharma also heard Mr. B. Sharma, learned additional PP for the state respondent. Mr. B. Sharma submits that he has received the service report of the respondent number 2, but no one entered appearance on behalf of the respondent number 2. And in that way of the matter,
Although they have not the party here, madam, but get the information.
No, we have made them part of the main petition.
It's
Yeah.
Ranjana Borwa. Ms. Srimati Ranjana Borwa is appointed as amicus to represent the respondent number 2. Registry shall reflect the name of Ranjana Borwa in the cause list as amicus for the respondent number 2, and also furnish the relevant papers along with the application to her well in advance and list the matter on sorted.
That may be given, Lordship. Next week, Lordship, before 15, Lordship.
13th.
Highly obliged, Lordship.
Items for admission, item 21.
May I please, your Lordship? Lordship, application under section 528 of BNSS for quashing the proceeding of sessions case number 245/22 pending in the court of
Honorable Additional District and Session Judge, Kamrup Metro. Allegation against me mainly 376 IPC. Lordship, first kindly may peruse the page number 31. There is marriage certificate. Informant and victims, accused and informant's marriage was performed on June 5th June 2017. After the marriage, they were residing together in a rented house. But after a few days, that informant seeking, she was seeking that social status may be given. But accused could not, because his family did not support her, support this marriage. And after 2 years, Lordship, page number 12 may be perused. There is FIR. FIR was
After
lost
2
9
years.
June. Lordship,
After 2 years.
2 years FIR was lost. 9 June 2019. Then Khatri PS registered a case against the accused and arrested him. And after few days, page number 33, Lordship. After few days, they entered a mutual deed of separation before the notary. And with this mutual separation deed, they approached the family court, Lordship. Kindly page number 38 may be perused.
Page number?
Page number 38. There is decree of divorce from the family court, not honorable family court. And line number 11, Lordship. I'll read the lines. Hence, both the petitioners mutually agreed that their marriage should be dissolved on mutual consent by agreeing that the petitioner number 2 shall not claim any financial benefit, maintenance, or permanent alimony in future from the petitioner number 1. It is stated that both the petitioners have agreed to withdraw all the cases filed against each other.
Page number? You were reading page number?
Page number 38 and line number 11. In second para. Second para, line number 11. Hence, both the petitioners.
Okay, allegation is prior to this order or after this order?
Pardon, Your Honor?
The allegation pertains to the period prior to this order or after this order?
Prior to this order.
After this order.
FIR, this case was filed before the family court 2021. FIR was lodged
So,
in 2019.
if there is divorce, and after that, if you have committed any such offense, then how can it can be quashed?
No, sir. No, Lordship. FIR was lodged in 2019. 19. Page 12. Page number 12. I was arrested and got bail from the court. But police searched very, after I think 2 or 3 years after that, police searched the case. So before searching, already divorce performed. Divorce already, mutual divorce was granted by the family court. So later, the searched case came to the Honorable Sessions Court. So they approached that their divorce also finished. But police told that because section is the 376, we cannot withdraw from here. We cannot make final report in the police station. Court will decide whether case can be finished or not. So then later the case was again came to the Honorable Sessions Court. But already divorce has been granted by the family court. And in the divorce decree of divorce, it is mentioned that whatever the cases against each other, they will withdraw.
whether she is not agreeable to withdraw the case.
No, no. Each petitioner, this petition is filed mutually. Both the informant and accused. This for passing.
After the grant of divorce,
Yes, sir.
she has refused to withdraw the case.
No, 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 no. Because case was in the main case was FIR case was in Khatripias. They approached that this case may be stopped here in the police station. But police told that because of 376, we cannot make FIR. We'll make we'll search the case and court will decide whether case may be withdrawn or not. Then later, after the search sheet, case was committed to the Honorable Sessions Court. Now, this case may be quashed. Both the informant and accused both mutually filed this petition to quash this proceeding.
No, the question is whether section an offense under section 376 IPC can be
Not applicable,
quashed.
sir. It's not applicable. In many cases, it is already by the apex court already held that if they are husband and wife, because in the time of the making FIR, when they lost the FIR victim, they were husband and wife in that time. After the marriage registration,
There are some decision.
Yes. Gaps in the script of Punjab.
No. Some other decisions are also there. 3 judge bench decision. Yes, Narendra Singh.
one is with me, sir. 376 position.
Srinaran versus State of Maharashtra.
Oh, yes, and that is another decision.
Yes.
Yes. Some guidelines have been laid down in that case, perhaps.
Yes, Doctor. Also not the investment.
Kopil Gupta. Kopil Gupta versus State of and City of Delhi. This from Honorable Supreme Court. Para number 16 and page number 8. It is similar case registered under section 376. The page number 8, it is observed. It is further to be noted that since the respondent number 2 herself is not supporting
Okay,
the prosecuted case.
we'll see the other judgment, Narendra Singh and Lakshmi Narayan. Those two, those decisions are of 3 judge bench, perhaps. We'll see some guidelines have been laid down there. We'll fix it on another date. Third, Mr. Your name, please.
Siraj Chaudhary.
Learned counsel for the petitioner. Ms. Bora, learned additional PP for the state respondent. Whether the victim was made a party here?
This is mutual petition.
It's applicant.
Applicant.
Or she is the applicant?
Yes.
Along with the accused.
Heard in part, list the matter on sorted.
18.
For further consideration.
18.
You keep this judgment with you and produce before the court on next day.
Highly obliged.
May I please appeal against the conviction, my lord. Impugned judgment is page 8. Start from 16, my lord.
Heard, Mr. B. Talukdar.
My lord.
Learned counsel for the appellant. And who will appear here? You are. Ms. S.S. Bora, learned additional PP for the state respondent number
Page 16, my lord. that's
State
my-
respondent number 1. This appeal under section 415 within bracket 2 of the BNSS 2023 is preferred by
I cannot. 20.
the appellant, namely Abdul Razak alias Abdul Razak, who stood convicted by the impugned judgment and order dated 7/7/2026 passed by the learned additional session judge FTC Nagaon in session within bracket T-2 case number 223 within bracket N/2024, whereby the accused was convicted under section 376 IPC and sentenced him to suffer rigorous imprisonment for 10 years and also to pay a fine of rupees 5,000 with default stipulation. Peruse the memo of appeal, the grounds mentioned therein, and also peruse the impugned judgment and order dated 7/7/2026. Admit, issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process upon respondent number 2. However, no formal notice is required to be issued to the respondent number 1 since Ms. Bora entered appearance and received notice. However, extra requisite copy of the petition of the memo of appeal be furnished to her during the course of the day. This shall call for the record from the learned trial court. Place the matter after 4 weeks. Is there any interim pair? No.
In time, my lord, I have filed IA for sentence, but that was not take to the. So may I pray for a date, my lord, so that I can place.
Mr. Talukdar, learned counsel for the appellant, submits that he has also filed an interlocutory application for granting bail to the appellant, but the same has not been listed before this court. Accordingly, it is provided that Regis shall list the interlocutory application along with this appeal on 3rd of September.
Obligement.
May it please your lordship. Senior counsel Mr. S. Botakur was appearing in this case.
Who?
Senior counsel Mr. S. Botakur. He currently cannot appear in this case. I am praying for an adjournment. Your Honor.
Okay, on the appeal being made by Mr.
Your lordship, case study was called for that we have not received. Your lordship starts it and verify.
This is criminal petition.
Lordship.
Criminal petition.
Yes, civil was called for.
Okay. Your name, please.
A. Lahokoria.
R.A. Locker, learned counsel for the petitioner. Submits that conducting counsel Mr. S. Borthakur is out of station and as such he pressed for listing the matter after 1 week.
Can it be fixed on 19th of August?
19th of August. Okay, all right. 19th of August. Ms. Bora submits that by order dated 27/7/2026 and 16/7/2026, CD was called for, but as per her instruction, the IU has submitted search sheet after completion of investigation. Accordingly, it is provided that Regis shall call for the scanned copy of the record from the learned trial court, fixing the matter on
Obliged.
May I please, your lordship? My lord, I may be allowed to withdraw this petition.
Why?
My lord, the petitioner was arrested on the strength of a non-bailable warrant, my lord. Petitioner was arrested, my lord, on the strength of a non-bailable warrant, my lord. And I have filed this criminal petition for releasing on bail, my lord. So other day, lordship has told me that, my lord, on criminal petition, there is a bar for bail, my lord. So
yes, extraordinary circumstances only bail can be granted.
my lord, my lord. So
Okay.
I may be allowed to withdraw this application.
Liberty?
My lord, with the liberty.
With liberty. Heard Mr. Halo, learned counsel for the petitioner, Ms. Assis Bora, learned additional PP for the state respondent. Mr. Halo submits that he may be allowed to withdraw this petition with a liberty to approach this court again by filing a appropriate petition. Pair allowed? This criminal petition stands to dispose of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
For hearing, item 46.
May I please your lordship? Lordship, in this case, the petitioner is aggrieved by an order, lordship, passed by the learned family court, number 3, lordship, whereby the petitioner's petition that he belongs to a below property line family member and he should be dispensed with filing assets and liabilities affidavit, that was rejected, lordship. Lordship, what happened, lordship?
No, the petitioner is below poverty line.
Lordship.
Then,
BPL, he belongs to BPL category, lordship.
yes,
So, lordship, what happened? May I submit a brief facts, lordship? Brief facts of the case. Lordship, what happened? Respondent number 2 and 3 are the parents of the petitioner, lordship. So they have filed an application under section 144 of the BNSS, lordship, seeking maintenance from the petitioner before the learned family court, lordship. And the case was posted on, lordship, for deliberation for the first time on 24 to 25, lordship. Lordship, we will find the order at Annexure 1, page 13. So, lordship, on that very day, after receipt of the notice, lordship, the petitioner appeared for his representative. And subsequently, the matter was posted on, lordship, 24/3, lordship, 24/3/25 for further deliberation. That is for filing assets and liabilities affidavit and hearing on interim maintenance, lordship. Lordship, on that very day, lordship, the petitioner's representative has filed a petition, lordship, petition number 507, lordship, that is Annexure 3, page 17. May I kindly have a look, lordship?
no. By order dated 24th of February 2025,
Lordship.
the principal judge has directed to file.
No, lordship, that impugn order, lordship, page 26. Page 26, Annexure 7.
What is page number 13?
Page number 13, lordship, the first order. When the matter was posted for appearance, NSR. So, lordship,
Impugn order is page number 20?
26, lordship.
26. Yes.
So, this is the impugn order, lordship. May I read, lordship?
Yes.
Petitioner number 1 and 2 are present. Opposite party is absent with step height. Petition number so and so praying for condoning his absence for today on the ground of personal difficulties. Had the representative of the opposite party, namely so and so learned advocate. Today is fixed for order on petition number 507 and 1215. Since the petition number 507/25 dated 24/3/25 filed by the representative of the opposite party on behalf of the opposite party under order 11 of the CPC, praying for directing the petitioner to produce the BPL card, which is issued by the authority in the name of the petitioners. It has been
You
stated.
come to operative portion of the order.
Gotcha. Operative portion, lordship, page 29.
Yes.
Mary, so peruse the case record. It reveals that the opposite party filed petition number 1215/25 has submitted that he had somehow procured the copy of BPL card issued by the authority in the name of his parents. As such, the prayer made by the opposite party filed petition number 507/25 is disposed of being infructuous. Now, as regard the prayer made by the opposite party filed petition number 1215/25, I am of the opinion that the opposite party is major and the ration card BPL card was issued in the name of his mother. And his mother, that is petition number 2, in spite of having ration card issued in her name, has filed her affidavit of assets and liabilities in the instant case. Furthermore, the opposite party filed petition number 507/25 has submitted that upon being produced the BPL card, which is issued by the authority in the name of the petitioners, a copy of the BPL card may be provided to the opposite party in order to prepare his affidavit of assets and liabilities. Hence, as the opposite party had already procured the same submitted by him, as such, the prayer made by the opposite party filed petition number 1215/25 is rejected. This is the reasoning passed by the learned Family Code number 3, Lordship. In my humble submission, though petitioner number 3 is having a BPL card in her name and he submitted the assets and liabilities affidavit, that does not, Lordship, permit me to file the BPL, the assets and liabilities affidavit, Lordship, as per the mandate of the Rajnesh versus Neha, Lordship.
No, whether the person below poverty line is prevented from filing assets and liabilities.
Yes, Lordship, kindly have a look.
Hmm.
The authority laid down by Honorable Apex Court, Lordship, the celebrated case Rajnesh versus Neha.
Hmm. What is the relevant
72.9, Lordship.
relevant paragraph?
Relevant paragraph is 72.9. Lordship, this is a long judgment, Lordship. Page 370, Lordship, kindly have a look. Page 370. Lordship, has your Lordship got it?
Yes.
Lordship, in case of parties belong to economically weaker sections, EWS, or are living below poverty line, or are casual laborers, the requirement of filing the affidavit would be dispensed with. So, Lordship, in that very judgment, Lordship, in para 81, kindly have a look, Lordship, para 81. If someone is not liable to file assets and liabilities affidavit, how the maintenance will be assessed?
Page number?
Page number, Lordship, 372, para 81, Lordship. This is no more race anti-grant, Lordship. A careful, as your Lordship got it, a careful and just balance must be drawn between all relevant factors. The test for determination of maintenance in matrimonial disputes depends on the financial status of the respondent and the standard of living that the applicant was accustomed to in her matrimonial home. The maintenance amount awarded must be reasonable and realistic and avoid either of the two extreme. That is, maintenance awarded to the wife should neither be so extravagant, which becomes oppressive and unbearable for a respondent, nor should it be so meager that it drives the wife to penury. The sufficiency of the quantum has to be adjusted so that the wife is able to maintain herself with reasonable comfort. Though, Lordship, this was pertaining to husband and wife dispute, Lordship, a ratio could be called out, Lordship, from this observation, Lordship, though this case is filed by the parents. So, Lordship, my humble submission is done, Lordship. BPL card is issued in the name of the mother of the petitioner. BPL card is, Lordship, issued as per the National Food Security Act 2013. And the mandate of the statute is that, Lordship, I have, Lordship, articulated, Lordship, in my rejoinder. Lordship, we find at page, Lordship, 67, Lordship, in my rejoinder, running page 67, Lordship. Lordship, section 13 of the National Food Security Act, women empowerment. The eldest woman who is not less than 18 years of age in every eligible household shall be head of the household for purpose of issue of ration card. So, Lordship, as per mandate of the statute, the card is issued in my mother's name, Lordship. Lordship will find a card, Lordship, by BPL card.
No, now what is your grievance here?
My grievance is, Lordship, I belong to a BPL family, Lordship. So I need not file the assets and liabilities affidavit before the trial court, Lordship. In spite of that, Lordship, I was directed to file, Lordship. Hereby the learned family court, Lordship, tried to override, whittle down, and circumvent the order passed by the highest court of the nation, Lordship. So that is my grievances. Lordship, in para 81, it has been unambiguously articulated by the Honorable Apex Court how the maintenance is assessed.
Admittedly, the BPL card was not issued in your name.
In my name, Lordship, that is correct.
Then?
That, Lordship, as per the mandate of the statute, Lordship, National Food Security Act, it is to be issued in the name of the eldest woman, Lordship. That is, my mother is the eldest woman in my family. So, Lordship.
No, does it mean that all other members of your family are below poverty line?
Lordship, to that effect, Lordship, in my humble submission, there is a competent committee, Lordship, constituted by the government, headed by the Deputy District Commissioner of the district, along with the Gram Pradhan of that locality, who will assess the financial status of all the members of the family, Lordship. So after such assessment, Lordship, my name was recommended, that is Porialor Mutkhanka Pass. My parents too. I am the eldest one, my younger brother, and my sister, Lordship. Total 5 members. That has been, Lordship, mentioned, member 5. After all assessment, Lordship, the committee has, Lordship, scrutinized.
Where is that report?
Lordship.
Where is that report?
Lordship, then I may be granted some time, Lordship, to collect that notification, Lordship, and assessment. Because I don't have any government job, Lordship. So, had I have a government job, Lordship, my names would have been excluded, Lordship, from the purview of the BPL. So, Lordship, I don't have any government job. And my income is admittedly below 4 lakhs, Lordship. In order to, Lordship, secure a BPL
So
card.
does it mean that even if it is agreed that you are below poverty line,
Lordship.
are you exempted from this granting maintenance?
No, Lordship, that I am not denying maintenance, Lordship. As per Lordship, paragraph 81 of Rajnesh versus Neha, Lordship, family court may well, Lordship, assess the maintenance amount, Lordship. So as per para 81, family court may proceed, Lordship. But family court.
No, you see, before the learned trial court, the family BPL card was not available.
No, Lordship, it was available, Lordship. Lordship, it was available, order transparent, Lordship. Page 26, Lordship. The impugn order itself indicates, Lordship, BPL cards were on record, Lordship. And the petition, Lordship, that is 1215, Lordship.
BPL card issued in the name of even it has not been issued in your name, it was issued in the name of your mother. Mother.
Lordship. Lordship, in the petition, Lordship, that is 1215.
So the recommendation of the committee as submitted by you was not before the trial court.
Lordship.
So how can the trial court, how this impugn order is illegal or arbitrary?
Lordship, because, Lordship, Porialor Mut Hodosho, members of total member of the family 5. Admittedly, there are 5 members in my family, Lordship. And there is a, Lordship, correct presumption, there is a legal presumption,
No,
Lordship.
you say even you are exempted from filing the assets and liabilities, affidavit of assets and liabilities, then you are bound to maintain the other side.
Lordship, as per para 81, family court may proceed, Lordship. That is not my grievances, Lordship.
And what is wrong with you to file the affidavit?
Because, Lordship, as per the mandate of the highest.
Because no, that's all I do. Admittedly, this card is not in your name.
Admitted,
so
Lordship.
if you strictly go by the direction of the Supreme Court, you are not entitled to any relief. You are bound to file it.
Lordship, in my humble submission, eldest woman of the family is my mother, Lordship. So card is issued in her name, Lordship. So I being the son, Lordship, my name appears in the card, Lordship. And as of now, Lordship, she has not disputed my name, Lordship, before the competent authority. If there is any grievances, Lordship, she may file appropriate petition before the competent authority to strike off my name, Lordship. That has not been done, Lordship, yet.
No, the person, no, the lady who has been fighting for maintenance, whether she will, she has the resources to.
I will apply for the BPL card first.
No.
BPL card, Lordship.
That is your business. What you can do it. And there is no infirmity in the impugn order. We dismiss this petition.
No, Lordship. I will.
You are trying to deny maintenance to your mother and relying upon her BPL card. Absurd position this is.
No, Lordship.
Absurd pair.
In my humble submission, Lordship, in as per para 81 family court may proceed, Lordship.
No. And you were trying to misinterpret the decision of the Supreme Court also.
Lordship.